Yes.
My lord, yesterday I moved a memo. The matter to be listed today, my lord, but due to minor office objection, the matter was not listed. Now it has been, I've complied the office objection, maybe at 2:30, my lord. There's extreme urgency in the matter.
No, without you complying the office objection,
But
the
earlier
matter to be listed.
Well, the matter, earlier I was done the needful, my lord, but again it was new minor office was raised, my lord. And we followed up, the file was not found. Then it was found, then complied with the minor office.
Yes, if it is, it will come tomorrow, not 10th, no 2:30. Yes. Yes.
Your Lordship, one matter for tomorrow, my lord, for admission, CP transfer petition. The date is given, she has to travel from Mysore to Chendraipatna, Hassan district.
When did you file? You filed or you're going to file?
It is already filed and it is also come up before the court. There is some office objection, it is complied. And now it has to be.
Tomorrow, yes.
Serial number 10 in third list, ma'am.
No, that mentioning is later, out of the list. Yes, call the list.
Serial number 18, please. Serial number
We'll
18.
call page
Sir,
wise.
call page
It
wise.
first mentions out of the list. Yes.
Transfer petition, my lord. Petitioner cannot travel from Mysore to Beltangadi. So kindly post it tomorrow, my lord.
No, when did you file?
Last week, my lord.
It is not listed till now.
Not listed.
Office objections are complied with.
Yes, ma'am.
All the matters, all these transfer petitions or any other matter, fresh matter, if the office objections are complied with, it shall be listed immediately next day. Yes.
Page wise adjournments. Each one, page 1, serial number 1, 2. Page 2, serial number 3 to 6. Page 3, serial number 7 to 9.
7.
Page
Serial number 18, please.
Huh?
Serial number 18.
8.
18, 1-8.
plus
They have not yet called.
I am sorry.
Yes.
page number 4, serial number 10, 11.
My lord, serial number 10, my lord. Serial number 10, I appear for the appellant. I have to take steps to respondent number 6 and 7 for the second time. I'll pay the process, my lord, within a week.
For that, the mentioning it will not be done. It will be called and then you can mention. Yes.
Please.
Page number 5, 12, 13.
My lord, serial number 12, my lord, is for non-amendment of cost title. My lord, 2 days time I pray for, my lord, I'll do the needful. It may be posted on Monday, my lord.
All these matters are for that. For that, no mentions are required. Please wait till your matter reaches. Yes.
Page number 6, serial number 14, 15. Page number 7, page
Seven.
number 17 to 20.
Serial number 18, please, my lord. I pray
Yes.
for 2 weeks time in this matter because the respondent number 4 is the deceased mother. He was aged at the time of filing an appeal. Just I want information whether she is 2 weeks time.
MFA of 2014.
2 weeks time. Where I need.
No, if they don't want to pursue, then let us close it. MFA of 2014. Again, 2 weeks time.
Yes. That is the reason.
Let's this matter next week. No further adjournments.
So, whichever.
Yes.
Page number 8, serial number 21 to 24. Page number 9. Okay, no. List 2, page 1, serial number 1 and 2. Page 2.
Lord, serial number 1, list 2, ma'am. Serial number 1, list 2. Only 1 week time may be granted to pay the process payment. To pay the fresh process.
In this interim order is there.
Yes, ma'am. Interim order is there.
Interim order of 2022 for paying. We will see. We will see.
My lord, already we have paid 2 times pay.
We'll see. We'll see. Will not adjourn. Will not. That's not the way. Yes. Wait for the matter.
Page number 3, 9 to 15. Page number 4, serial number 16 to 20. Page number, list number 3, page 1, serial number 1 and 2. Page 2, serial number 3 to 6.
Serial number 5, list number 3, serial number 5, 1 week time I pray for this.
Why?
We appear for the respondent.
My lord, I have to produce some documents, new documents.
What documents in a 2013 MFA?
Yes, my lord, I agree, but it is a dismissed case.
No, Mr. Rathur, will not do. You should have done it by this time. Will not do it. Yes, next.
Number 6, my lord.
Yes.
I want some 1 week time, my lord.
Why?
Because I hurt my fingers. Yesterday while stapling, I got it stapled. Blood oozed out. I'm running fever.
Then counts for the appellant finally next week. No
6
further
and
time.
9 also, my lord. 9 also.
Yes.
Page number 3, serial number 7 and 8, page number 4, 9 to 12. page-
Serial number 10.1, my lord. On behalf of the insurance company unrepresented, in connected appeals, Arni Sivananda is appearing. Lordship, kindly take notice to Arni Sivananda. I will serve the copy. There are two options.
Do it when the matter reaches.
In that appeal, I
Huh?
felt the owner's appeal is that.
What is the number?
Serial number 10. I-
So
Next is the claimant's appeal.
Climate
10.1
appeal,
is the
10 climate appeal.
Where the insurance
Understood
company is
that.
also the party, they wanted some copy of the advocate.
When the matter reaches, we'll do that. Yes, next.
Page number 5.
My lord, I request for day after tomorrow, my lord.
Why?
My lord, insurance appeal is not there, my lord. I collected the insurance appeal copy today, my lord. So, my lord, day after tomorrow, my lord.
Finally, at the request of
Please, my
and
lord.
counsel for the appellant, after tomorrow, no further adjournments.
Much obliged, my lord.
Yes.
Page number 5, serial number 13 to 16. Page number 6, serial number 17.
Please call the list.
List number 1, parted matter, serial number 1. Prasanna BR, for petitioner.
My lord, I'm filing
the
memo of retirement.
Bara.
Retirement.
29-1, what is the order? Land counsel, the petitioner submits that already 80% of the construction is completed. It is stated that even before the trial court, he will not claim any equity or any third party rights. So the construction is stopped at this stage to damage the structure.
Yes, my lord.
Hmm.
My lord, we try to contact the parties here. We not able to reach. We have sent a
Okay.
legal notice also to this.
When was it received?
It was postal track is my lord.
Huh?
It's delivered on 28/2. 28/2.
Then counsel appearing for the petitioner submits that. They have issued a note, they have written a letter dated 26/2/2025, asking the client to provide necessary instructions to prepare and file an affidavit as per the directions of the court dated 29/1/2025, failing which they'll retire from the case for want of instructions. It is along with the memo of retirement, they have also filed the track consignment to show that the same was delivered on 28/2/2025. Then counsel submits that as there are no instructions, they were permitted to retire from the case. The petitioner is permitted, the counsel is permitted to retire. The registry is directed to delete the name of the counsel and print the name of the party. Delete from part third. This is smarter before the regular bench. Yes.
Number 2. Aishwarya R for petitioner.
Yes, my lord.
Tushar BS.
I'm filing the asset and liability details.
I've already filed it in office, my lords, 2 days back. I've served the copy also.
We'll take it on some other day,
Please,
filing it today,
please,
file
Yes.
it in the section.
please.
Then counsel for the respondent, then counsel appearing for the wife. As submits that he is filing the statement of assets and liabilities today, and the counsel appearing for the husband submits that they have already filed the statement of assets and liabilities. This is matter when,
Except 12th, my lord, any date may be fixed.
yes, Aishwarya, when?
My lords, 2 weeks' time, my lords.
No, my lords, because in trial court also, the contempt petition, each and everything, it is harassing, my lord.
That's why.
This is matter on 17th March.
Much obliged.
Till number 3. Arun Govind Raj, petitioner.
Appearing for the respondent, my lord. My lord, on the last date, we were deciding on the interim custody plan, and there seemed to be certain clarification that had to be provided with respect to it being interim or a permanent plan. We had suggested it's going to be a interim plan, my lord. My lord, recently certain information has come to light with respect to the minor daughter's health issues, my lord. So with respect to that, I'll be filing an affidavit with necessary documentation, my lord. Therefore, I seek that adjournment may be given, my lord, because the senior is also held up in another court arguing a part heard matter to them.
May I make this request, my lord? Apparently, the child is now spoken about certain things in school. The impact that she's suffering on account of the parents' separation and their discord. This matter, my lord, has never been, your lordships have never had the benefit of interacting with the, your lordships, yes, your lordships have not had the benefit of interacting with the parties, my lord, in chambers. May I request on Monday if it could be taken up in chambers at 5 o'clock? I think, my lord, there are certain things which will, which may not be, which may not be in a position.
If you would apprise this court with the necessary documents and an affidavit that we will file, we will inform this court what exactly is it that the minor daughter is going through.
Second, list this matter on Tuesday at 5 p.m.
Obliged. My lord, on Monday, my lord, if it is
Tuesday, I said.
Monday, my lord.
Monday is inconvenient to the court.
My lord, 13th, my lord.
What is your inconvenience?
No, there are other matters that's also coming up, my lord. The seniors
at 5 p.m.
Why the senior is required? Court will interact with the parties.
My lord, with respect to the child being brought to the court, my lord, I'll have to receive instructions from my senior as to he would be at the right position to make submissions before this honorable court. Because if I'm not wrong, I'll have to interact with the respondent herein as well, my lord. With respect to the child being brought, my lord, let the senior would like to come forward and address this honorable court, after which decision may be taken, my lord. We're not against it. We were the ones to insist on it earlier, my lord.
For all small things, all these arguments are not required. Just find out and tell the court officer when is it convenient. Let that date I'll give. Let her come. There is nothing for the senior to argue advance arguments in this.
My lord, with respect to the child, it has been, if I'm not wrong, my lord, the respondent had informed me that the child herself was having certain hesitation, or she's expressed herself with respect to the interaction with the court that she's had on the earlier date with the family court, my lord. So with respect to that, I have to give a detailed affidavit, my lord.
We are not concerned with what is her hesitation. She has to come when the
Understood, my lord. My lord, all that I asked for is that the matter.
What I'm asking you about what the court is asking is, please find out what is the.
My lord, the matter may be passed over then, my lord. I'll consult and then I will get back to you.
I'm sorry, I think my learned friend is slightly mistaken. I'm not asking for the children to be brought to the court. I'm only asking for your lordship's interaction with the parties. We're not considering the developments that have taken place.
No, not only that, when they're putting forth something that is not right with the child, you need to interact with the child also.
Then in that case, may I make one request, my lord. The school of the child has had an interaction, video call with the parents, which the school has recorded. They've informed the parents that they have recorded. Your lordship may permit me, my lord, I will request the school to permit to produce a video recording of the call that they have had with both the parents, where they've expressed what difficulty the child has expressed to the teachers.
My lord, to that effect is what we are submitting, that we'll file an affidavit
No, this has to be
along with necessary records. It is not just the school interaction. Following up with that, the school has given certain instructions as to what necessary steps have to be taken. Even with respect to that, with respect to child health issues, will apprise this court, my lord. A date may be given. 7th also works, my lord. I'll come forward with the affidavit and the necessary documents.
If they have the school recording, then it's fine. My lord,
we do not have the school recording, my lord.
Then therefore, kindly permit me to, my lord, if your lordship permits me, my lord, by an order, to secure the recording from the school, I will, because your lordship will have the benefit of knowing what the school has discussed with both the parents. It's a video call recorded only by the school. We are not allowed to record the video call. The school has a video recording, and they're refusing to give it because they say only if the court directs, then they can provide it.
Admitted that after the order is passed by this court.
The matter may be passed over, my lord. I'll have my senior try to address this honorable court. He's better instructed by my client. That's all that I asked for, my lord. The matter may be passed over.
Every time these, no,
No, my lord,
the
it was-
matters are posted for hearing. Either the senior has to be here. Last occasion also, you said the senior was not
My lord,
there.
the matter may be passed.
Either the senior has to be here or you should have the instructions.
My lord, the matter may be passed over. I'll have my senior be present.
Pass over.
Number 4, petition, T.
I am for the respondent. my lord.
Press for 1 week time.
Why?
Senior is going to Dharwad High Court.
Huh?
Dharwad High Court senior.
So you'll not practice in this court?
1 week.
Why you were not there yesterday? Matter is posted for dismissal. Today you come up very casually with the request that the matter has to be adjourned because senior has gone to Dharwad. How is that? MFA, can't you argue? Why is the senior required for this?
1 week time.
No, it will come tomorrow. You should argue, or else court will pass orders. This is matter tomorrow under the same caption.
Still number 5.
Lord, I am for the appellant, my lord. This matter is posted from yesterday to today. I have argued yesterday.
Appear for respondent claimant.
My lord, shall make submission. This appeal is by the KSRTC, my lord. Challenging the, my lord, though I have questioned this my lord, negligence aspect because the petition is filed under section 163 of MV Act, my lord, I may not pursue very seriously. Though there is a total negligence on the part of the claimant himself, my lord, he has chosen to file a petition under section 163A. My lord, regarding quantum of compensation, my lord, the tribunal has rightly awarded compensation towards pain and suffering as per section 163 of MA Act, rupees 5,000. And also pay towards medical expenses, 15,000. My grievance is only with regard to the loss of future income that has been awarded by the tribunal. My lord, though the tribunal has rightly disbelieved the evidence of PW2 doctor. Doctor has stated 27% physical disability and it disbelieves it but takes 25%, only reducing 2% disability. But the petitioner himself has prosecuted the case. He has given evidence. He has filed the plaintiff petition. And even before the High Court also, he is...
Let us see, please come to that. Please come to that
injury aspect, my lord.
Yes.
Page 12, internal page 12. My lord, it is true. The petitioner has contended that he was working as a mechanic in Honda Motors, Narsapura Industrial Area, Kolar, and he was earning rupees 40,000 per annum. It is restricted amount. And due to the said accident, he is unable to attend any work, and in view of the said accident, he has sustained brain injury, that is brain fracture, right temporal bone with acute FTP, EDH with midline shift to the left, and features of herniation are noticed and finally diagnosed as traumatic brain injury. And he has taken treatment as inpatient from 16/1/2015 to 28/1/2015, FTP craniotomy and EDH evacuation. Hence, the contention of the petitioner is corroborated with the discharge summary produced by the petitioner as per Exhibit P5. Since the petition claim compensation under section 163 of MV Act, as per the second schedule of MV Act, if the injuries are grievous in nature, 5,000 for pain and suffering and is entitled. Regarding loss of future income, it is true. The very condition of the petitioner is that he was working as a mechanic in Honda Motors Limited and he was earning rupees 40,000 per annum, restricted amount. Though the respondent has produced the salary certificate of respondent and monthly salary of rupees 9,900, but the only consideration income of the petitioner per annum is rupees 40,000 only. Further, the age of the petitioner as per the discharge summary is 25 years. If so, on the date of accident, he was aged about 25 years, multiplier applicable as on hand as per so and so, 18 multiplier. As per the opinion of the doctor as well as the discharge summary, the petitioner has sustained permanent disability of 27.77%. He has also deposed that at present, the petitioner is having tension type headache, disabling from doing any strenuous work, right sensorial deafness and decreased vision, and his right eye all secondary to trauma had sustained, etc. On the basis of the guidelines for assessment of physical impairment in the neurological condition given by DGHS, WHO, AM, so and so. So, the considering the evidence of the doctor and condition of the petitioner who appears before the court, the said percentage of disability is little higher sided, and hence the court can consider the permanent disability at the rate of 25%. Here, my lord, the doctor has whatever the disability stated is not at all stated by the claimant either in the claim petition or in the evidence. And he has given evidence and he withstood for cross-examination, and Now he is pursuing the appeal also. And there is no, because he was working in a Honda showroom, my lord, abruptly he cannot be removed from the service unless there is some proper document. It appears that he is continuing in the service and getting regular income, and there cannot be any loss of future income. Therefore, my lord, the tribunal,
How it appears that he is working?
unless he produces the, he has been removed from the service because of the injury or disability.
Yes. Yes, what do you say?
Therefore, my lord, my humble submission, my lord, tribunal has awarded 1,80,000 by taking into consideration of 25% disability that may be reduced. That is my humble submission.
On
That's
what
all.
basis it should be reduced? And
Because there
what
cannot
is
be
the-
so much of
No, no,
disability
what
and
is the
evidence of.
expertise? No. What is the expertise of the court to say, this is not the disability, this is somebody is competent to say, what is a disability? Somebody has said it. What is the cross-examination on that?
My lord, cross-examination, my lord, I'll read the cross-examination portion.
Record is there.
Evidence of PW2. Examination.
Yes.
My lord, cross-examination, I'm having only the examination chief.
Then,
Of
no, even the court cannot say, he said 27.77, I will take 25. How the court has arrived at 25, but not
because taking into
27.7?
consideration of the condition of the petitioner that he has prosecuted the case, he has given evidence, he has withstood for
No, in that
cross-examination.
case, why should, no, in that case, why it should be 25? The court should have completely.
That is on higher side. That's what I'm telling. That is my submission.
That is the finding of the court is wrong. The court should say what is wrong with the evidence of and how you have cross-examined him, what you have elicited.
Cross-examination, I have got only examination chief, my lord,
No,
of
the
Dr.
court is not court is not an expert to decide what is a disability.
Yes.
Yes, please
This
come.
is my submission, my lord. I leave to you.
Please come. Agreed with orders passed in MBC number 88 of 2015, dated 20th July 2016, whereby the tribunal had granted an amount of ₹2 lakh as compensation. The insurance company is before this court.
KSRTC Corporation.
KSRTC is before this court. The facts of the case are, the respondent claimant had filed the petition under section 163A of the Motor Vehicles Act, seeking compensation of an amount of ₹10 lakhs. It is his case that on 16/1/2015, at about 2:15 PM, he was coming from Chintamani to Kolar by riding his motorcycle on the correct side of the road. At that time, one KSRTC bus came from opposite direction at high speed in a rash and negligent manner on the wrong side and dashed the petitioner's motorcycle. And as a result, he has sustained head injuries and immediately he was shifted to the hospital, wherein it is found that he has sustained traumatic brain injury and treated by FTP, anatomy, and whereby he was treated. And he has taken treatment as an inpatient from 16/1/2015 to 28/1/2015. And it is a case of the claimant that is working as a mechanic in a Honda showroom and earning an amount of ₹40,000 per annum. And he has spent an amount of ₹2 lakhs towards the treatment. The trial court, the trial court had considered the evidence of the doctor who has deposed that the claimant has sustained permanent disability of 27.77. The court gives a finding that on considering the evidence of the doctor and the condition of the petitioner who appeared before the court, the said percentage of disability is little higher and hence the court had taken the disability at 25% and granted the compensation of these 2 lakhs under different heads as per section 163A of the Motor Vehicles Act. Next part. Counsel appearing for the case RTC submits that the compensation that is awarded, particularly with regard to the permanent disability, is on the higher side. When the court has disbelieved the evidence of the doctor, the court ought not to have taken 25% as disability. When the claimant is active, when he is able to take care of his day-to-day work and he is doing the job also, continuing the job, the court ought not to have taken the disability at 25%. He submits that the same hand needs to be the disability that is considered by the court is on the higher side. That needs to be reduced. Next parallel, counsel appearing for the respondent claimant submits that when the doctor has given the disability certificate and when the doctor was examined and when he has stated that as per the guidelines for the assessment of physical impairment in the neurological conditions given by the DGHS-WHO-AIMS, he has come to such conclusion. Just like that, the court cannot come to the conclusion that is on the higher side. And already court had taken only 25%, which itself is not correct. And now the appeal filed by the KSRTC saying that it shouldn't be, the court shouldn't have taken 25% is also cannot be considered. And the appeal deserves to be dismissed. Next part. Having heard the counsels on either side, there is a material on record. When the doctor has given a disability certificate, saying that the disability is 27.77% as per the chart, as per the guidelines of DGHS, WHO, and AIIMS. And the court simply gives one observation saying that the disability is little higher side and reduce the same to 25%. How it is on the little higher side, there is no discussion. When coming to the disability, there are certain guidelines that has to be followed while assessing the same. And the doctor is a competent person who can decide about the disability, and the court can look into basing on and when he is examined, it is for the insurance company to elicit the cross-examination whether to prove that the assessment that is made by the doctor is contrary to the guidelines. In this case, no such effort is being made. In that case, the court cannot say that it is on the higher side without any basis. As there is no appeal preferred by the claimant, this court is not going into the said aspect. In view of the above discussion, this court is of the view that there are no grounds to interfere, and accordingly dismissed. The amount in deposit shall be forthwith transferred to the trial court. Yes.
Much obliged.
Obliged.
For appellant, BC.
And for the appellant in this matter, my lord. The claimant appeal, my lord.
Yes.
Payment appeal will, my lord, and for enhancement and challenging the liability fixed on the insurer, owner of the offending vehicle, my lord. Due to
Sitaramaro, liability is fixed on whom? On the owner of the vehicle. Owner
yes,
of the
ma'am.
vehicle.
Rider of the vehicle did not have driving license. That ground only, my lord.
They say that he had learner license. However, the same is not produced before the court.
Might.
Milords, it is claimed that he had learner license while riding the vehicle. However, the same is not produced before the court. So the trial court holds that there is violation of policy terms and liability is fixed on the owner.
Then pay and recover will apply.
Please.
We'll do that. Then what about on enhancement? Enhancement.
Accident in the year 2014, my lord. Income has to be taken 8,500, my lord.
How
The
much is
tribunal
taken?
taken 4,500. The tribunal has taken, my lord, 4,500 instead of 8,500, my lord.
2014, 8,500. Please come to the table. What are the amounts that are granted?
At internal page number 13, my lord.
Pain and agony, 40,000.
Pain and
Medical
agony,
expenses.
40,000.
How many days he was in hospital?
11 days, my lord, 11 days. Age 50 years, my lord.
This food convenience and attendant charges will make it 11,000. Then coming to this loss of future income, 8,500
into 12.
What is the multiplier?
13, my lord. Aged about 50 years, 13. Multiplier is 13, my lord.
Yes, Mr. Charamala, 13. And what is the disability?
13%, 1-3.
Disability assessed in page number 17, my lord. 20% disability of her left lower limb and 18% disability of right upper limb.
So
Upper
the
limb.
whole body, how much is taken? 13%.
Yes.
Yes, my lord.
Will come to 1,72,380.
380.
Then loss of income during later period. Will take 2 months. That will come to 17,000. Loss of future amenities. Another 5,000. Expenses. 10,000. Comes to 3,29,180. Please come. It's not recording. Huh? Then why you are not calling them? Not working. I'll call them. The appeal is filed. Agreed with the orders passed in MBC number 792 of 2014 dated 17th April 2018. Whereby the tribunal has granted compensation of an amount of rupees 2,15,060 and fix the liability on the owner of the vehicle. The facts of the case are the facts of the case are the petitioner was walking by the road near RMC Yard, Hechenpura Road on 14/1/2014 at 7 p.m. The rider of the Discover motorbike came from Arkal Gold in a rash and negligent manner and dashed against him from the backside, causing the accident. Immediately, the appellant was shifted to the government hospital and was referred to Memo Hospital. The right radius and left tibia and fibula bones got fractured. Many operations were conducted by the doctor. On the advice of the doctor, she was discharged and she is still under treatment and had spent an amount of rupees 80,000 towards the medical expenses. And because of the injuries, she has sustained the disability and she is not able to work. And claim compensation of an amount of rupees 8 lakhs. The trial court, the tribunal, when it comes to the negligence, has given the finding that the accident has happened because of the rash and negligent driving of the driver of the offending vehicle. When it comes to the compensation and the liability of the insurance company, the court, it is a case of the petitioner that, what is your income?
Sir.
According to you?
Sir.
All these details should be there.
$10,000 per month.
In the case of the
Coolie and agriculture.
working as a coolie and earning an amount of rupees 10,000 per month. The court had taken the salary. How much is the income taken?
4,500.
4,500. Considering the evidence of the doctor with regard to the disability to the limb, court had taken 13% to the whole body and granted an amount of rupees 91,260. Towards pain and agony, 40,000. Medical expenses, 63,800. Food, conveyance and attendant charges, 5,000. Then and the loss of income during the later period, 5,000. And for future remedies, 10,000. Or put together, an amount of rupees 2,15,060 is granted. And the liability, the court had held that the driver of the offending vehicle had obtained the learner's license at the time of the accident. He was alone riding the said bike and hence violated Rule 3 of the Central Motor Vehicles Rules. Hence, the insurance company is not liable to pay any compensation. The next para, the learned counsel appearing for the appellant is before this court, questioning on the aspect of liability as well as seeking enhancement of the compensation. On the aspect of liability, it is stated that though the driver of the offending vehicle is not having a valid driving license as on the date of the accident, but the appellant is the third party to the policy. And as such, in the light of the law laid down with the Honorable Apex Court in Swerensings's case, the principle of pay and recover will apply in this case. Then coming to the aspect of enhancement, it is submitted that the accident had taken place in the year 2014. the court ought to have taken the income at 8,500. Instead of that, the court had taken 4,500.
500.
4,500.
500, madam.
Huh?
4,500.
Court had taken 4,500. He submits that even on the loss of future income, loss of amenities, food conveyance and attendant charges. The court granted the compensation which is not reasonable and on the lower side. And the needs and the same needs to be enhanced. When counsel appearing for the insurance company submits that the court had rightly fixed the liability on the driver as he was not having a valid driving license to drive the vehicle. And on the compensation, on the enhancement, it is submitted that when there is no evidence to show that he is earning 10,000 per month, court had rightly taken 4,500. 4,500, and even on all other counts, the amounts which were granted were reasonable, and no interference is called for with a well-considered order passed by the tribunal. Next, having heard the counsels on either side, produce some material on record. The first aspect with regard to the liability is concerned, though the driver of the offending vehicle is not having a valid driving license. In the light of the subtle law, in case of surrendering, the insurance company is still liable to pay the compensation and record the same from the owner of the vehicle. In view of the same, in this case, the insurance company shall pay the compensation to the claimant and then record the same from the owner of the vehicle. Next, coming to the aspect of enhancement, the court under the head of pain and suffering and medical expenses, the reasonable amounts are granted. When it comes to the food conveyance and the attendant charges, he was there in the hospital for 11 days. Court had granted 5,000, and hence the same is enhanced to 11,000. Then the loss of future income due to disability. This accident had taken place in the year 2014, but considering the notional income at 4,500 is on the lower side, and this court is considering the income at 8,500. 500 into 12 into 13 into 13 by and 13% disability, the loss of future income will come to 1,72,380. Coming to the loss of income during the laid up period, considering the injuries, and as the income is considered at 8,500 for 2 months, it comes to 17,000. Then the loss of future amenities, court had granted 10,000, and the same is enhanced to 15,000, considering the occupation and the disability. In the light of the law laid down in so and so, towards legal expenses, an amount of rupees 10,000. Altogether, the claimant is entitled for an amount of rupees 3,29,180. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 2,15,060 to 3,29,180.
For orders matter, serial number 7, A.N. Krishnaswamy for appellant.
Waiting for the appellant, my lord. Seeking 1 week time for the substitute service.
Steps to be taken in respect of R1 since a notice issued 2-3 times. No, what are you doing from 2012?
On that time.
You should have taken steps by this time.
Yes, my lord. I'll take my now.
A week's time, finally.
Yes, my lord.
Within a week, finally, a week's time is granted for taking steps for filing an appropriate application for substituted service of notice on R1 and R2. If the application is not filed, the appeal shall stand dismissed without further reference to the court. Yes, next.
Serial number 8,
Much obliged.
Tarun Rao BC.
Therefore, responding.
B.N.
Manoj, the legal representatives are already on record, Manoj. I filed a memo to hold that R2B and R2C as the LRs of deceased R1?
Yes,
Yes, my
a memo is filed. Memo is filed stating that the LRs of the deceased respondent number 1 are already on record. That is respondent number 2B and 2C. And they were brought on record on 30/10/2019, and they were treated as LRs of the deceased respondent number 1. Accordingly, the memo is taken on record and the respondent number 2B and 2C are as the legal representatives of respondent number 1. Necessary amendment shall be carried out in the cost title. Yes, next.
hearing may be fixed, ma'am.
This calculation one. Yes,
Hearing may be.
hearing immediately will come in the final hearing. Immediate, Mrs. Mata in the final hearing.
Serial number 9.
Is appear for appearance in all cases, my lord. I may be permitted to serve one of the advocate who is appearing on standing counsel.
Memo
my
for
lord.
dispensation of notice to R1 and R3.
Maybe dispensed. my lord.
Why? Who are R1 and R3?
R1 is a place of expertise, the owner, my lord. R3 is the another one of the insurance company, my lord. The liability is fixed on the respondent number 2, my lord.
It is
That's
submitted
right.
that
Please, my lord.
R1 is the owner of the vehicle
Please, my lord.
and R3 is one of the insurance company.
Insurance company.
Whereas the liability is fixed on
On
R2.
the respondent number 2, my lord.
Respondent number 2.
Please.
As such a memo is filed stating that notice to R1 and the notice to R1 and R3 may be dispensed with. Accordingly, the memo is taken on record and at the risk of the appellant, the notice to R1 and R3 is dispensed with. Next.
My lord, in respect of respondent number 2, my lord, I may be permitted to serve one of the counsel, my lord. In all 3 cases, my lord, 3 advocates are there, my lord. I may be permitted to one of the advocates.
How can you ask and how can the court give such a
My
request?
lord, Mahesh is appearing in VC, my lord. I can't serve it physically, my lord. And Srisaila, and also the PB Raju advocate is there, my lord. One of the advocate.
It is for the insurance company to engage the advocate. Court will not direct them to say, no, do engage only one advocate, not so many advocates. That's not right. Whatever is the means available to you, do it. So in all the matters,
3 advocates.
in all the matters, in all the 3 matters, same dispensation of notice to R1 and R3. And the counsel for the petitioner shall serve the copy of the appeal memo on the respondent counsels within a week. And after the, unless this
My lord,
matters
2
for
weeks, my
hearing.
lord. Mahesh, I have to serve through RPAD, my lord. That's why, my lord, I am
So
seeking.
what is this process? Why this RPAD and all? Advocates, there should be a procedure to serve the notices.
Like, he is not appearing physically, my lord. That is the problem, my lord. 2 weeks may be granted, my lord. I will serve it to all advocates, my lord.
No, where is Mr. Mahesh?
Last occasion also I have inquired.
No,
my
like,
lord.
how is it? This is the work has to go on, even for serving notice and serving the papers. If it is taking this much of time, then it's difficult.
And moreover, there is no any colleagues, my lord, to him, my lord, to serve the copy, my lord. That is the difficulty, my lord.
Yes, Mr. Mahesh.
That's why, my lord, I am asking, my lord, one of the advocate, sir. my
And that you cannot ask, court cannot
lord.
grant.
Please, my lord.
Oh, Mahesh, sir. Mahesh, sir.
MFA.
I have served,
That is
my
waiting
lord,
for service of notice on
PB Raju, I have served, my lord, earlier, my lord. For that, my lord, there is no acclaimment, but I have lost that one.
PB Raju you have served?
Served in the year 2014 itself, my lord. That's why, my lord, I will again served, my lord, in all 3 cases to PB Raju, otherwise Srisaila is. They are
Post
physically
this matter
available.
after 2 weeks for final hearing.
Connected matters, my lord. In all cases, I have filed the memo connect along with the connected matters, my lord. only one memo along with connected matters, my lord. If necessary, my lord, I will file.
Memo takes hardly, you can write now and also give.
Please, my lord, I will.
Please give in all the
Give.
matters.
Including 3 cases I have filed.
Please give.
Please, my lord.
Cell number 10, P. Vijay Kumar for petition appellant.
I appear for respondents, madam.
My lord,
has
I am for
happened?
the appellant, my lord.
Yes.
My lord, the respondent number 6 and 7. They
Who
are
are they?
and respondent number 1 to 5. All of them are residing in the very same address and they are all family members. I have taken notice on the first occasion, my lord. I want to know what has happened. Notice sent to respondent number 6 and 7. Because they are already aged 76 years and 79 years in the year
No such
2000.
person.
They are all
No
residing in the same address. Same address.
You wanted
They are
to
all
know what
family
has
members.
You wanted to know.
The minor claimant is appearing before the court. They have to say. He is appearing for their own children. Respondent advocate is before the court. Let him submit what is happened to that
Make a
respondent
submission,
number 6 and 7.
Now the counsel for the
Whether they
respondent
are
is
alive or they are
appointed as a-
residing separately or whatever it is.
What is the relation of your client with this 6 and 7?
Now
They are the
counsel for
parents.
respondent-
Just wait, Mr. Vijay Kumar.
Now the
please,
counsel for the respondent is appointed as a panel advocate to the KSRTC, madam.
Who?
Pradeep Kesi. Pradeep Kesi. We already issued NOC, madam, today.
You are representing him.
Please, madam, Pradeep Kesi.
So you are
Last week-
representing Mr. Pradeep Case.
Please, madam. Last week only as appointed as a panel advocate to the KSRTC, that's why. Ivat koಟ್ಟಿದ್ದೀವಿ.
Pradeep Casey has issued an NOC.
Who to whom he has given?
But name.
Sampath.
They have to send it to the party.
Sampath.
I'm representing Pradeep Kesi. Now in view of the appointment as a panel advocate, madam.
That I understood. To whom you have given no objection.
Parties, madam.
Parties.
Parties, please, madam.
Parties they have given, not to the advocate.
Please.
It is submitted that but you have to file a retirement memo.
Please, madam, I will file, madam.
This
And
is
also
matter.
acknowledgement for having served the notice to them.
This is matter. Next week, it is submitted that Ms. Pradeep Casey now is appointed as a advocate for KSRTC's panel advocate for KSRTC. And they'll file a memo to that effect. Yes.
Please, kindly name may be deleted. Name may be deleted.
You have to come
Please.
file a memo, then it will be deleted.
Please, madam.
Yes.
Cell number 11, O. Mahesh for appellant.
Appellant in the connected appeal.
O. Mahesh. Ravishankar Shastri.
Take steps for R1, my lord.
No representation for the petitioner, for the counsel for the, no representation for the appellant. This is matter for dismissal.
Appearing in
That is MFA 5182 of 2016. Yes, what about it? Your case, all process is,
This is completed.
no, in the same case, one,
I have sought
two
dispensation, my lord.
advocates. Huh?
I have sought for dispensation since Melody was placed ex parte before the trial court. On the other hand, Melody insurance company want to serve them, my lord. Is the owner and.
We'll see tomorrow for dismissal.
Cell number 12. Cell number 12.
Appearing for the appellant, my lord. My lord,
Subramanya Devaya.
my lord, it's for non-amendment of cost title, my lord. My lord, I to pay for 2 days' time, my lord.
Question is
My lord.
25/1/2024, 16/10/2024, 14/2/2025. These many are the orders.
I'm an advocate on NOC Baka, my lord. I filed it only on 2 days prior to this. Lord, 2 days, my lord. Maybe taken up on
Finally,
Monday.
2 days time is granted for filing the amended cost title, or else the appeal shall stand dismissed without further reference to the
Please,
court. Yes, next. Yes.
Cell number 13. Manjunath ND. First time notice.
First time. Notice first time, even for first time also, process not paid. To whom notice has to go? To the driver of the vehicle?
R1, sir.
R1,
Yeah,
you appear for R.
EC Sitaram Rao has filed it.
No, 13. Are you referring to
Cell number
13?
13,
Please.
sir.
It
13.
shows
filed Wakalat.
PB Raju for R2.
PB R1 is not.
Wakalat not filed.
R1, my lord, BC Sitaram Rao was filed. the Wakalat.
Wakalat. Then what happened to the office? Why is this endorsement? Get it?
But in 18th March 2024, he has filed the Wakalat.
Yes, filed the Wakalat for R1.
R1.
I think I think the number you're getting confused, I think.
2288 MFA. MFA 2288, sir.
Serial number 13 allo.
13, list number 1.
Okay.
Your seeking, I think, in that.
Wrong.
sir.
It is wrong, madam.
No representation for the petitioner, for the appellant. This is matter for dismissal tomorrow. Yes.
Cell number 14.
For appellant, I'm filing memo to dispense the notice to R1. Regarding R2, my lord, I had already paid the process, my lord. It is saying that no such person. R2 is the owner of the vehicle, man. The liability is fixed on the R3, man, insurance company. I may permitted to file another memo for R2 also, my lord.
You can do it right now.
Yes, my lord. I'll file it right now.
So a memo is filed seeking dispensation of notice to R1 and R2.
Yes, my lord.
Both are the memos are taken on record and the notice to R1 and R2 is dispensed with at the risk of appellant. Yes. Poses matter for admission. Yes.
Cell number, hearing on your interrupted application.
Have you served papers on Pradeep? Yes. Next.
Cell number 15.
Appearing for appellant, my lord. I pray to allow the IN number 1 of 2016, which is for condolence in the applying this MFA, because the appellants are both are senior citizens who are aged more than 90 years, who are bedridden right now, and they are not aware of this.
Where is
appeal
Sita
method.
Ramarao?
We are not aware, my lord.
Sita Ramarao.
Yes, given. But they have not served the appeal memo on the delay application to file an objection. There is a delay of 1,283 days.
No, that's not the one. It's 2152.
Then he has not given that number.
It's 2152.
Secondly,
Ask
striking.
him to come.
Please kindly pass.
Pass over. Yes.
Cell number 16.
No representation on behalf of both the parties for dismissal tomorrow. Yes, next.
Cell number 17.
This matter has been settled before the Lokadat. Maybe refer to Lokadat, please.
It's settled.
Arrived and approved. We have to report before the Adalat.
It is submitted that the matter is already settled. The registry's director pays the same before in this case before the Lok Adalat.
Much.
Cell number 18 for admission, 18 urgent, cell number 19. 19, A.N. Krishna Swami.
Hello.
N.K.
Who appears for the respondents?
N.K. Siddheshwara.
PCR is also there.
Yes, my lord.
List this matter for final hearing. Admit post for final hearing. Yes.
Much obliged, madam.
Cell number 20.
Same.
Abu.
Same.
Admit final hearing. Cell number 21. S.V. Hegde Mulkan.
For the appellant, appeal of the insurance company on the question of liability regarding the.
All are served, nobody is represented.
Yes, ma'am.
No, some.
All are served, my lord. One
Likit-
Likit was appointed as amicus curiae before the previous bench. Lord, this is regarding the driving license issue, my lord. And this is the matter arising under the Workmen Compensation Act. My lord, the deceased was a driver. He was driving the bus and met with an accident. And my lord, that we have produced the driving license. My lord, the owner of the vehicle, my lord, what has happened is filed a claim petition. Petitioners have filed a claim petition before the tribunal. And my lord, the tribunal, my lord, awarded 3,98,000 in the first instance. Then, my lord, we have filed an appeal before this honorable court. and the matter was remanded back to the tribunal to consider only in respect of driving license. Our contention was the driving license what they have produced was a fake driving license. Then, my lord, only based on, only to decide the issue, my lord, the matter was remanded. Then, my lord, we have produced before the tribunal, my lord, judgments of the writ petition, my lord, of this honorable court, and also the district forum judgment, wherein, my lord, the owner of the vehicle has challenged, because we have repudiated the own damage claim, and then they have filed a claim petition before the insurance company. It was repudiated, and then they went to the consumer forum, and the consumer forum rejected their claim petition, saying that the driving license was bogus, and they filed an appeal before the state commissioner, and that was also dismissed. Against that, my lord, the writ petition was filed, and that was also dismissed by this honorable court. And then, my lord, before the tribunal, on remand, we have produced, my lord, all these three proceedings judgments, and also endorsement issued by the licensing authority at Chennai. And that clearly says, my lord, their driving license, what they have produced is a bogus driving license, and no such entries were found in their records.
That is produced by the owner of the vehicle.
Owner of the vehicle has produced certain endorsement saying that the vehicle, that person had driving license.
No, the liability is fixed on you completely.
No, the liability has been fixed on us.
Let's see that.
If your lordship is hearing, because three proceedings are there, my lord. Earlier proceedings and also writ proceedings were also there, and all those judgments were produced, available on the records. If your lordship posts the matter for final hearing, it can be disposed of, my lord.
You can dispose it off now.
Yes, my lord. Your lordship may kindly appreciate what the tribunal says, my lord, the question in
Come to the order.
Yes, my lord. My lord, your lordship may kindly come to page 8 of the judgment, my lord.
Page?
Page 8 of the judgment.
8.
Yes, my lord.
Yes.
Paragraph 5, my lord. In order to prove the case of the prisoner, prisoner number 1 got examined herself as PWN and got 15 documents, exhibit P1 to 15, and closed their side. On behalf of the respondent, assistant manager has been examined, and officer of the company has been examined as RW2 and got marketed documents. R1 and R2 closed their side. At the earlier instant, petition was allowed before the Commissioner for Workmen Compensation on 6/8/2009, awarding 3,98,800 along with interest to the dependents of the deceased workman prisoner. The Oriental Insurance Company challenged the award before the Honorable High Court of Karnataka and so and so, which allowed with a direction to the Commissioner to frame issue whether Mahbub did not possess valid driving license. At the cost of repetition, this tribunal would like to state that the Honorable High Court of Karnataka has remanded the matter for fresh consideration to provide an opportunity to both the parties to establish all the important issues regarding liability of the insurance company, to make good the compensation, particularly in the light of the findings recorded by in the parallel proceedings initiated by the owner and driving license produced by him was a fake one. However, the Honorable High Court of Karnataka had not touched the findings of the Commissioner pertaining to the status of the petitioners as dependent on the deceased Mahbub Pasha, and that the deceased Pasha was workman as required under the Workmen Compensation Act. He died during course of employment, age and salary, etc. The tribunal is required to give findings on the validity of the driving license and afford an opportunity to both the parties to lead evidence on the same and shall record specific findings. Now, my lord, the findings. Subsequently, the matter was transferred to this court as per the direction of this so and so. Then, my lord, your lords may kindly appreciate. Additional issue number 1 is framed, and both the parties were permitted to lead evidence on that issue. Petitioner number 1 further examined before this court and produced exhibit P14, duplicate driving license of the deceased Mahbub, and exhibit
Wait, we come to page 12.
Page?
Page 12, internal page 12.
12, yes.
Running page 23.
Yes, madam. Exhibit P13 and 14, which established that duplicate DL is issued as original DL was damaged and surrendered with effect from 5/5/2006. Same authority has issued endorsement dated Exhibit R2 and Exhibit R3, which are contrary to each other. It is a burden upon the insurance company to examine the author of the document, but the insurance company has not taken proper. Yes,
No,
madam.
there are two documents. You
Yes,
have
my lord.
produced art.
We have produced it and they have also produced it.
Exhibit P13.
Yes, my lord.
Uh.
And our document speaks, my lord, your lords may kindly appreciate the document what we have produced. We have sent a letter, original driving license endorsement, and we requested to give whether such endorsement.
No,
Yes,
if the same authority has
Yes.
given one endorsement.
same, my lord. And we have taken out summons to the RTO.
You examine them,
He didn't turn up in spite of twice, my lord, the notice sent.
then some steps have to be taken.
Again, my lord, the tribunal closed the case. That's why we couldn't take further proceed with the matter. Your lordship,
It's not that you are remediless at that point of time.
that is there, my lord, but thing is.
So why
Yes.
should now whatever is the earlier orders of the court and other things?
Yes, my lord.
As per the remand order passed by this court,
Yes,
the issue is framed, adjudication was done.
yes.
And as per one endorsement, according to them, he is having the deceased was having.
But my
a
lord, your
driving
lords may kindly appreciate. Before the consumer forum, we have produced all these documents. Consumer forum conclusively held that, my lord, that the driving license which was produced.
No, but in the
Before it
MFA
was a fake.
In the MFA, court has left it, though all these were stated before the court.
That's
court
correct,
has
my
left
lord,
it
but we
to-
have, from our side, my lord, we
No,
have.
That is the burden lies on you to prove.
We have discharged that burden.
How?
We have taken out summons to the RTO ready.
So
We have,
we are taking summons and because he has not turned up.
we have produced
Then court
it.
has
My
to.
lord, your lords may kindly appreciate. Endorsement issued by the same authority clearly speaks about that. Insured owner,
Where will it go? Exhibit P13, where will that exhibit P13 will go? Same authority.
same authority, my lord.
And then
This endorsement also speaks about that.
the burden lies on you.
Burden,
You
my
are not
lord,
discharged.
my lord, the owner must come and come forward and speak about that, my lord. This was the.
No, when
Yes.
you are asserting that, the burden lies on you.
We
But you
have
not
discharged, my lord, from our side.
By just summoning him, you will not. No. Please come.
But apart from this, your lords may kindly appreciate. 3 proceedings, judgments we have produced before the tribunal.
In MFA, all these things were brought to the notice of the court. After that, the court had not had not expressed any
My lord, this
opinion.
is, my lord, workman
Remand the
compensation
matter.
matter, my lord. Ultimate
The insurance
burden is on
company-
whom?
If the insurance company is not pursuing it, we can't help it.
Ultimate burden is on the, my lord, the owner of the vehicle. And he didn't produce any material.
Please come. Agree with the order dated.
Just only, my lord, that's the only content.
Agreed with the order passed in ECA number 2 of 2015 dated 22nd July 2015. The insurance company is before this court. The respondent herein has filed a petition under section 10 of the Workmen Compensation Act for award of compensation along with interest of 12% from the date of petition to realization for the death of the deceased in the accident. The petitioners are the wife, children, and mother of the deceased. It is a case that he was working as a driver with the first respondent in the bus since 5 years on a monthly salary of rupees 4,500 and rupees 50 per day as bhatta. On 7/5/2016, the deceased is proceeding the said vehicle along with paid passengers from Bangalore to Bijapur as per the instructions of the owner. When he reached the Budni cross at 6:30 AM, the deceased trying to overtake one vehicle by following rules. At that time, one canter vehicle driven by its driver in a rash and negligent manner with high speed came from opposite side and dashed both the vehicles and caused the accident. Due to the impact, the deceased sustained fatal injuries and also fractured and grievous injuries all over the body and died at the spot. And in that regard, a case was registered. The claimants, who are the family members, have come up with this petition seeking compensation. The earlier, an amount of rupees 3,98,900 was granted as compensation, and the same was questioned by the insurance company by filing MFA number 7839 of 2009. It is their case that that the owner of the vehicle has went before the consumer forum.
Yes, ma'am. Yes, ma'am.
Owner of the vehicle has gone before the consumer forum. And it was argued before the forum that the driving license was a fake driving license. And the district forum has upheld the same. Then the owner has challenged that was confirmed by the district forum. That is confirmed by the state forum. That was questioned by the owner of the vehicle by filing WP number 13795/2008 before this court. And this court has affirmed the said orders. In view of the same, it is argued that the driving license was the driver was holding a fake driving license. As such, the insurance company has no liability to pay the compensation. Then this court has remanded the matter. And after the remand, an additional issue is framed, and both the parties were permitted to lead evidence on the issue. And Exhibit P14, the duplicate driving license of the deceased, and Exhibit P15, identity card issued by the Maxicab Owners and Drivers Association, was produced. And the insurance company got examined itself as RW2 and produced Exhibit R3, certified copy of the order in WP number 13795 of 2008.
Exhibit R2, madam.
Exhibit R2 and also filed Exhibit R2. The same authority has issued endorsement, that is Exhibit R2 and also Exhibit P13, which are contrary to each other. Then the tribunal has held that it's a burden of the insurance company to examine the author of the documents, but the insurance company has not taken proper steps to secure the witness, that is assisting licensing authority, Red Hills, Chennai. Exhibit P13 reads that the deceased Mehboob had driving license, which was valid from 12/6/2003 to 11/6/2006. The court gave a finding that the driver had a valid driving license as on the date of the deceased has a valid driving license as on the date of the accident. And the same is fortified by Exhibit P14. And nothing was elicited in the evidence to disbelieve these two documents. And further, the insurance company has not placed cogent evidence to establish their contention the deceased Mehboob was holding fake license on the date of the accident. And considering all this, the court had held that the insurance company is liable to pay the compensation, and accordingly granted compensation of an amount of rupees 3,98,800. Next, counsel appearing for the respondent for the appellant insurance company submits that when Exhibit R2 discloses that the driving license is a fake driving license, the court ought to have considered the same and ought to have given a finding that the insurance company ought to have exonerated the insurance company from the liability. It is admitted that though they have taken, in fact, they have taken steps to examine the concern, but in spite of the same, he has not appeared before the court to give the evidence. And counsel further submits that it's a burden on the owner of the vehicle to prove the same, and he has failed to prove that there is a valid driving license, and wrongly the tribunal had fastened the burden on the insurance company. The light of Exhibit R2, the appeal of the insurance company has to be allowed. Next paragraph. Though notice is served on the respondents, no wakalat is filed, and an amicus curiae is appointed on behalf of the respondents, and there is no representative. Then the amicus curiae has not appeared before the court. Next one. Having heard the learned counsel for the petition, appellant, counsel for the appellant, produce the entire material on record. It is a contention of the insurance company that in the light of the orders passed by the district forum, the state forum, which is affirmed by this court in the writ petition, that the driving license, the deceased license is a fake driving license. In the earlier round of litigation, when the MBC was allowed, and then the insurance company has filed an appeal before this court, that is MFA. This court, considering all these contentions, has remanded the matter to the trial court, directing the trial court to frame an additional issue in this regard. And accordingly, an additional issue was framed. And both the parties, both the insurance company, as well as the claimant, has adduced the evidence. Exhibit R2 and Exhibit R3, both are issued by the Assistant Licensing Authority, Red Hills, Chennai, who has given two certificates, two endorsements, which are contrary to each other. When it is a specific case of the insurance company that the deceased was having a fake driving license, the burden lies on him. And it is observation of the court that they have not taken the insurance company to have taken such a stand. They have not taken the correct steps to examine the concern. And considering Exhibit P13 and the other evidence, the court has come to the conclusion that the insurance company is liable to pay the compensation. This court, having perused the judgment and also the arguments, finds that the tribunal has rightly observed and rightly held the insurance company liable, and then insurance company has failed to discharge their burden and prove that the deceased was having a fake driving license. Accordingly, the appeal is dismissed. The amount and deposit shall be transmitted to the trial court forthwith.
Apply.
22, L. Srikanth Rao for appellant, M. Sanjeev Shetty.
Giving the wound certificate. Trial court record cannot come the certificate. The insurance appeal challenge the quantum of compensation awarded.
Where is the counsel, Mr. M. Sanjeev Shetty?
They are served and unrepresented.
No counsel?
There is no counsel.
Yes.
In this case, if you lordship were to look to the exhibit P3.
No, let me first understand what is the case.
Sir, the accident is the accident is dated 28/8/2014.
Is a case of death or
Injury case.
injury?
And the petitioner sustained simple injuries as per exhibit P3 just now again. And
How much compensation they have claimed?
the tribunal has granted, it is discussed at para 25 of the judgment, your Lordship, ink page 21. Mary, as per exhibit P3, wound certificate, the petitioner has suffered simple injuries. No doubt the petitioner has taken treatment from 29/8/14 to 29/14 for 5 days at Pragati Specialty Hospital, Puttur. That in this case, though the claimant petitioner has claimed the 75,000 toward medical expenses and other incidental charges, I am of the opinion that careful scrutiny of exhibit P8 contains 6 medical bills for having taken treatment for injuries suffered in the road accident. The total amount of bills produced by the petitioner is 16,937, which is rounded up to 70,000. However, to meet justice, I am of the opinion that 17,000 is to be awarded towards the medical expenses. Further, it is just and reasonable to award 50,000 under the head of pain and suffering. Further, due to the injury suffered, the petitioner, there is a curtailment of enjoyment of life. Therefore, it's just and reasonable to award rupees 21,000 towards loss of amenities. Further, it's well settled principles that the law that any amount of compensation will not bring the happiness to the petitioner, as he will be a sufferer throughout his life. Further, it's clear that the petitioner was hospitalized for a period of 5 days. During the hospitalization, he needs attendance and also might have spent some amount towards conveyance. Therefore, it is just and reasonable to award 5,000 under the head of attendance charges, 5,000 under the head of conveyance charges. Further, during the hospitalization period, the claimant needs nutritious food. Therefore, it is just and reasonable to award 5,000 rupees under the head of food nutrition, nourishment. Further, the evidence of PWN goes to show that due to the accident, he has taken bed rest for a period of 3 months. However, I am of the opinion that the income of the claimant can be assessed at 6,000.
What is this discussion? There is a curtailment of enjoyment of life. 21,000 towards loss of amenities.
And 15,000 towards future prospects.
Oh.
Since it is a public money, though the amount of award is meager.
No, what we'll do is pain and suffering will grant 10,000. Medical expenses as
17,000 as it. And all the 3 heads convinced 15,000 is granted. That may be.
Loss of amenities not required. Loss of earning 1 month will grant. Which year is this?
14. It is
8,500.
500. It's 8,500.
Attendant charges, conveyance, food and nourishment, 15,000 is granted.
5,000 it could. And future medical expenses may.
Comes to 40,500. Please come. Agreed with orders passed in MEC number 187 of 2015, dated 2nd January 2017. The insurance company is before this court. The claim petition is filed seeking compensation of an amount of rupees 6 lakhs for the injuries sustained by the claimant in the accident that took place on 28/4/2014 at about 10:30 p.m. when the claimant was walking on the left side of the Puttur Mani State Highway, Bolvar, Puttur, Kaspa Village, Puttur. It is a case of the claimant that a car suddenly came from the petitioner's backside in a negligent manner and dashed against the petitioner. And to this impact, he fell down on the road and sustained severe grievous injuries all over the body. And he has incurred a lot of expenses. And it is his case that he's earning 10,000 per month.
He claimed that he was earning 10,000.
Earning 10,000 per month. The tribunal has held that the incident, that accident has taken place because of the rash and negligent driving of the driver of the offending vehicle. Exhibit, wound certificate is exhibit?
Exhibit P3 is the wound certificate.
Exhibit P3, as per exhibit P3.
My lord, it is 12,000. He has claimed 12,000 per month.
12,000. As per exhibit P3 wound certificate, he has sustained simple injuries. A court in the order has also observed that he has sustained simple injuries. Court considering exhibit P8, 6 medical bills had granted 17,000 as medical expenses. And 50,000 is granted on the head of pain and suffering. And also, court has observed that there is a curtailment of enjoyment of life. So 21,000 towards loss of amenities. And the court had granted 5,000 each under the head of attendant, conveyance, food and nourishment. Then towards loss of earning during the treatment period, an amount of rupees 12,000 is granted. Considering the income at 6,000. And towards 15,000 towards future medical expenses was awarded by the court. And put together, an amount of rupees 1,30,000 is awarded by the court. Land counsel, next para, land counsel appearing for the insurance company submits that the compensation that was awarded by the tribunal is contrary to the evidence and contrary to the settled principles of law. It is submitted that exhibit P3, the wound certificate, discloses that the claimant had sustained simple injuries. Even as per the court, the same was observed. And when the claimant had sustained simple injuries, granting of an amount of rupees 50,000 towards pain and suffering is on the higher side. It is stated that in a simple injuries, question of loss of amenities, and when he was in hospital for 2 days, attendance, conveyance, food and nourishment at 15,000 is on the higher side. Further, without there being any evidence, how the court has granted future medical expenses as 15,000. Even for that also, there is no basis. He submits that the amount that is granted by the tribunal needs to be reduced. Next para. The notice is served in the respondents. No wakalat is filed. On their behalf, next para. Having heard the counsels on either side, produce the material on record. The admitted, the facts in the case are that the accident, the claimant had sustained simple injuries. According to him, he was in hospital for 3 days or 2 days?
5 days.
He was in hospital. He was in hospital for 5 days. Earlier I said 2 days or somewhere, 5 days. He was in hospital for 5 days. And the wound certificate reveals that he had sustained simple injuries. And in that case, on what basis the court had granted the full attendant charges at 15,000 and the loss of amenities, pain and suffering at 50,000 and future medical expenses without any evidence is not known. All the compensation that is awarded by the tribunal is on the higher side and without any basis. In that view of the matter, the order impugned it requires to be seeks interference from this court. Accordingly, this court is granting the compensation. Pain and suffering, 10,000. Medical expenses, 17,000. Loss of earning during the later period, considering the accident of 2014. The income is taken as 8,500. Attendant food and transport, 5,000. Altogether, the claimant is entitled for an amount of rupees 40,500. Accordingly, the appeal of the insurance company is allowed by reducing the compensation from 1,30,000 to 40,500. The amount in deposit shall be forthwith transmitted to the trial court, and if any excess amount is deposited, the insurance company is at liberty to withdraw. Yes, next.
Number 23, N. Krishna Swamy for the appellant.
Hearing for the appellant, my lord.
And for the respondent number one, my lord.
Have you any objections for this? Have you filed your objections for this IA 1/17?
I have not received the copy of the IA along with the document, my lord.
This IA is of 1/17.
I'll produce today itself.
And counsel for the appellant shall serve the papers
What is it?
and all along with the annexures of IA number 1/17 on the counsel for the respondent in the course of the day.
Yes, ma'am.
Yes. And how much time you require?
2 weeks, my lord.
Let's just matter on 20th of March. Yes, next 24.
24, Nagarajan for appellant.
English is the
And IFA for the appellant KSRTC. The matter could be disposed of as far as deposit is concerned. The statutory deposit itself is around 50% in almost all the cases. The award itself is less
But
than.
why you have not deposited?
Well, we have deposited 50% of the award amount by way of statutory deposit. Well, about 10,000, about more or less, in some cases, 1 or 2 cases.
Non-filing of memo for having
Yes, yes.
deposited the amount is what is endorsement?
Well, today I have received the information, I will file it, madam.
Please
The
do
matter
it.
itself could be disposed of. Even records is there, trial court records is there.
That's what I'm saying. You deposit the amount and that memo is filed.
I have already deposited, but trial court records is there.
Amount.
Yes, I'll verify, madam. They have not filed any memo on this. Only statutory, if at the time of filing, they have filed
If
it.
you file the memo, we'll take up this matter on Tuesday.
Please.
Oh.
Record is there. Trial court record is there. It will be entered in the record itself regarding the deposit.
Look at it.
Reference ಇಲ್ಲ ಇಲ್ಲ ಅವ್ರು ಮೇಡಮ್ ಫೈಲ್ ಮಾಡಿ ಮಾತ್ರ ಗೊತ್ತಾಗುತ್ತೆ ಅದ್ರಲ್ಲಿ ಗೊತ್ತಾಗಲ್ಲ ಯಾಕಂದ್ರೆ ಡಿಫ್ರೆಂಟ್
The land counsel for the petitioner shall file a memo with regard to the deposit of the 50% of the award amount by Friday. If it is filed, list this matter under the same caption on Tuesday. Yes.
Okay.
23, 24, 24 is Raju.
25 ಆಯ್ತು
That's the entire batch.
Serial number, list number 2, serial number 1, Naveed Ahmed for petitioner.
Yes, give the file.
Kindly, 1 week time will be granted to furnish the PF. Already we have paid 2 times PF for issuing notice to respondent. But the postal stated that no such person is there and that address.
No. 2022, you obtain a stay from this court. On a transfer petition.
Yes.
If 3 years, if this is pending before the court, how much time it will take to dispose of the main matter?
Lord,
And the advocate will be, there must be some advocate for her in the lower court, trial court.
yes,
Why have you not taken notice on them?
kindly permit me to serve.
Huh?
Kindly permit me to serve the hand summons.
Land counsel for the petition is permitted to serve the hand summons on the counsel appearing to the respondent before the trial court and shall file a memo to that effect by 12th of March, or else the CP shall stand dismissed without further reference to the court.
Interim order may be extended.
Interim order earlier granted is extended till then. Yes, next.
CV Manjunatha.
Petitioners. And 2 weeks granted.
For what?
Substitute service. Substitute.
Before notice, before the trial court. And someone same order, default order.
Okay.
Yes.
Serial number 3. Serial number 3.
Yes,
Ravishankar.
yeah, for the petitioner lordship. There's a transfer petition from Anekal to,
Punishing of 1,000 so and so, 100 and so to issue notice to respondent.
what is 1,000, ma'am?
Process is not paid.
I had paid, ma'am.
Look at it, look at the,
Neither. Amount of fee of 1,101 deficit process to be spent.
Okay, I mean, whatever they had asked, I had paid. So, anyway, you can give me a date. I will,
please do it.
sure, lordship.
The petitioner shall do the needful by Friday, or else the petition shall stand dismissed without further reference to the court. Yes,
Serial number 4. RB Deshpande.
no representation for dismissal tomorrow.
Serial number 5.
What fee has been paid? Madam?
Huh?
Needful done, madam. What fee has been
Paid,
paid?
and counsel for the petitioner submits that the needful is done post after service of notice. Yes,
Non-payment of court.
that's what he says. He has done the needful. Next 6.
Serial number 6. Yes, Venkateshwaran. Compliance. form.
This is a transfer case of a civil petition.
It says that non-compliance of office
Uh,
objection.
It's very minor. I can do it right now because the file was moving.
Do it.
Yeah, right now I do.
Petition is permitted to comply. Keep it, we'll see, afternoon. Pass over.
Yes, ma'am.
Yes, 7.
7. Ravishankar K.
For the appellant, madam. Malad in LAC,
Non-forthcoming of presiding officer signature at entire certified copies of the LAC judgment.
I
dated.
produced the certified copies of the order passed by the judgment and award. By oversight, my lord, the presiding officer signature is not forthcoming, my lord. Office objection may be overruled. My other office objections are compliant.
Do, show that. The office objection is regard to the presiding officer signature in each paper is not found. Then counsel submits that it's a certified copy of the judgment considering the same. The office objections are overruled. Yes, next.
Serial number 8.
Issue notice to the respondent. There is a
This is
delay.
the respondents.
Please.
Yes, next.
So, sorry, my lord, week's time may be granted to comply the office objection. Week's time may be granted to as the last chance, my lord, please. Sorry, my lord.
Finally, a week's time is
Please,
granted to
please.
comply with the office objections, same default clause.
Please.
Yes, next.
Appear for the petitioner and serial number 9.
Yes.
This is the petition for letters of administration.
Hmm.
Office has raised an objection stating that serial number 1 of the list of movables is not maintainable.
Is not?
Is not maintainable.
Hmm.
Lords may kindly see, these are e-stock options.
Let's see.
Permit me to just. My lords, I'm producing the letter of appointment of the deceased, my lords. The deceased was employed with Broadcom India Research Limited.
Hmm.
My lords may kindly turn to serial number 8 on page number 3, other benefits,
Hmm.
right at the top of the page.
Hmm.
You will also be eligible for all other company benefits and incentive programs like performance-linked stock options. Now, this has been granted in the parent company, which is in the USA. Now, I need the letters of administration to give it to the company here so that they will contact the parent company and transfer it to my account, my lords. The accounts are all in Bangalore. I have, my lords, may kindly see,
First, let's see the office objection.
my lords.
Let's see the office objection.
It only says that it's not maintainable.
No, that's, we look at it. What is that? Let's see the Succession Act and basing on what they say.
My lords, 278 doesn't say anything contrary to that, that I cannot,
That's what we look at it. What is this objection they're saying?
I don't know which section, nothing they have told me, my lords. They've just said it's not maintainable. I asked them, they just said it's not maintainable. So that is why the endorsement says that it devolves on the estate of the deceased. That's my.
No, this application is filed under which provision?
278, my lords.
Let's read 278.
Letters of administration.
Let's see.
Petition for letters of administration. Application for letters of administration shall be made by petition distinctly written as aforesaid and stating the time and place of the deceased death, the family or other relatives of the deceased and the respective residences, the right in which the petitioner claims, the amount of assets which are likely to come to the petitioner's hands, where the application is to the district judge, these E and F and 2 do not apply, my lords. Now, may kindly see page 4 of my petition, my lords. In that I have stated stocks.
We'll pass over. Call them. What is this? Ask them what is the subject. Pass over. Tomorrow?
No, my lords, I'm.
Pass. Yes. Yes, next.
My lords, would it be taken up in the forenoon session itself?
Yes. Yes. Next.
Tomorrow.
No, pass over. Ask them to come.
Ready.
Yes.
Cell number 10. Hearing on interlocutory application. P. Mahesha for appellant.
I am appearing for
Yes.
appellant in this matter, my lord.
I have 1/24 for recalling the order dated 8/1/2019.
Yes, my lord. I have filed this 16 matters, my lordship. Totally, the similar 16 matters I have filed, my
Where
lordship.
is the respondent?
Last occasion, my lordship, I have served all the copies once again.
They were not present on the last occasion.
They have present, my lordship. They said that, my lordship, I have not record. I have served all the copies in the last.
Please inform them, we'll take up this matter tomorrow.
It's,
No representation.
it's a
for
government.
the- That's what,
yes,
that's why I inform him. No representation on behalf of the respondents, then counsel is present, counsel for the appellant is present. Let's just matter tomorrow.
All 15 matters have been disposed, my lordship. Only
We'll,
one.
we'll,
single-
once he is there, we can dispose it all. Yes, next.
Question number 11, petition.
For the petition, my lord.
Being for respondent.
The petition is filed by the wife who is the respondent before the trial court in MC number 5241 of 22, my lords. My lords, the petitioner is
Seeking transfer from where to where?
Bangalore to Mysore, my lords.
Bangalore to?
Mysore.
Where are you, where is the husband is working in Bangalore?
Working in Bangalore, my lords.
Oh.
His home and everything is in Bangalore, my lords. I am situated presently in Mysore, my lords. Looking after
With your, with your mom?
Mother-
in the
mother-
with the parents?
parents, my lords. I have a disabled child, my lords, who is handicapped and is 7 years old, my lords. I have to look after him.
When is the MC filed?
2022, my lords.
And why did you file this in 2024?
No, my lords, the notice was served on me later, my lords.
When is the notice, sir?
In 2023, my lords, during the last stage of 2023.
When is this petition filed? In the last months of 24? What is the stage of the proceedings before the family court?
Family
Now
court,
the stage is, my lord, they have taken time for cross examination, my lord.
no,
Now it is,
Trial has commenced.
yes, my lord, trial is commenced. Trial is commenced, and moreover, at the instance of the petitioner, my lord, petitioner was supposed to quit the job in Bangalore and directed the petitioner to stay in the house of the petitioner, my lord. Thereafter, my lord,
So
petitioner,
when
the quarrel took place, my lord.
trial has commenced,
no, my lord.
Time-
Actually, I have not represented in this case, my lords. The petitioner has not represented in the trial case, my lord. She has not even filed her objections also, my lords. Directly, it has been posted for evidence, my lords.
Evidence.
It has not, she has not been represented.
where is the docket proceedings? Take that.
Oh, I'm sorry.
And she has not been represented even by an advocate.
Why? When you receive the notice, you should do something.
No, my lords, as per my instructions, she has not received.
No, you were only saying you received notice at the end of 2023. No, whenever you remember and whenever you want, just like that, you can't come to the court.
No.
You obtain stay, therefore, my lord, the proceedings are not.
On 2/11/2022, you have received the notice. RPAD signed, received, signed,
RPD signed and received.
sent and received.
Yes, ma'am.
On 2/11/2022. Respondent absent and files IA number to engage the counsels. So this is done without the instructions. You are saying all this. 2022, you sought formation to engage the counsel.
Please, madam. As per my instructions, the petitioner said she has not.
There is an element of science, refer the matter for mediation. Mediation VMC report not settled. The counsel for respondent filed objections to the main petition in 2 sets
My lords,
on
as per-
19/6/2023.
as per my instructions,
That's what I'm saying. You are not properly instructed.
please.
Maybe I could do more. Generally, they know the order sheet.
Even in Mysore also a case is a criminal miscellaneous is pending before.
Might be, but what are you doing from 2022? And why did you waste the court's time? Where do you get about the trial and all? Nothing, it doesn't reflect. Show, please, show to the court.
Please, madam. It is posted for plaintiff evidence finally.
Plaintiff evidence.
Petitioner evidence. Finally.
Nothing much has taken place.
Thereafter, they have approached the Sam court, my lord.
So that's why, so nothing, the trial has not commenced.
It is
Commence in the
posted
two
for,
sense.
after the mediation is filed, my lord. Posted the case for plaintiff evidence. Now, my lord, the fact is, matter
Oh,
petitioner is
you
a.
have a- You have a disabled child.
My lord,
Who
not
is
disabled,
taken
my
care
lord.
of
He
by
is
the
not
mother?
disabled. My lord, the facts of the trouble started, my lord. Lordship, can you turn to my statement of objection, my lord?
No, we are not on that. You have a, no, we are on a transfer petition, not on
That's
the
what,
merits of the
now,
matter.
my request is that, my lord, I'm the only son of my mother is suffering from serious illness and I have to take care. And your lordship, I have produced the photograph. She is aged about 78 years, my lord. I have to take care of her, my lord. Petitioner is working as a Zomato boy, my lord. And whereas the respondent is working as a teacher and I have produced the salary certificate. my lord.
Teacher where?
Teacher in, my lord, your lordship, can I turn to?
My lords. this is
Chetana
all-
Public School
In?
in Chitravana Resort, Mysore.
That is where, which place?
In Mysore only, madam.
Oh.
In Mysore only she is working and she is getting more than 40 to 50,000 salary, my lord. Whereas the petitioner is respondent is a Zomato boy, is hardly earning, my lord. After the marriage, my lord, she insisted the petitioner to quit the job of Zomato and directed the petitioner to respond to join the petitioner, my lord. After she went, my lord, she used to stay for a week together out of the.
That's all on the merits of the matter, Mr.
Therefore,
Counsel.
my
We are
lord,
not, we
now
are not going to that.
my lord, may I make one request, my lord? I will cooperate with the petitioner for speedy disposal. I will pay the whatever necessary charges. I will pay
You
the
are a Zomato.
Zomato by, my lord, for traveling expense.
And how will you pay her travel?
My lord, it will meager amount only,
No,
my
it's
lord.
not alone about the travel. You have a differently abled child.
My lord, no, my lord, she is the child is taken care by the mother, my lord. My case is that, my lord, petitioner used to stay out of the house for a period of 15 days, 1 month with her lover, my lord. She is not coming to the
Where the child is staying.
staying with the mother, my lord, with the grandmother. She is
Maternal or maternal?
my lord, mother of the respondent, petitioner's mother's house, my lord. Mother-in-law of the petitioner. She is child is staying with the mother-in-law of the petitioner, my lord.
No, my lords. The child is staying with the mother itself.
No, my lord.
Present petition is filed.
Madam, may make one thing. Madam, I will pay necessary charges. I will complete the evidence within two, 3 hearings, my lord. I will cooperate, my lord, because I have to leave the age.
How can the trial be completed in 1 or 2
My
hearings?
lord, let there be a direction to dispose of the petition within 2 months, my lord. I will cooperate, my lord.
Why should the court tell that? There are so many other matters which are more, which
My lord,
are
your lordship, my lord, your lordship, she is living in a building like this, my lord. I am living in a rented house. I have to take care of my old mother, my lord. I will produce the photograph. Your lordship, kindly see the
If
photograph.
you go to Mysore, you don't have to pay anything for her.
No, my lord.
No, you are
Not that, my lord. My apprehension is that, my lord.
You are stressing
My lord,
upon the
I have to
financial
be
aspect.
there along with my mother. She is aged
My
more
lords,
than 70.
they are a joint family, my
She
lords.
is suffering from illness.
No, you are saying that you are a Zomato boy. You will be outside, doing your
My
work
lord,
in the daytime.
I will take care, my lord, as and when immediately calls comes, my lord. Otherwise, my lord, it is a very hardship for the respondent, my lord.
The present petition is filed, seeking transfer of MC number 5241 of 2022, pending on the file of the Second District Principal Judge Family Court at Bangalore to Family Court at Mysore. It is, the facts of the case are the marriage of the petitioner and the respondent solemnized on 29/6/2015 at Mysore, and in the wedlock, they're blessed with a male child on 8/4/2016. In view of the differences between the parties, a petition is filed on 25/8/2022. That is MC number 5241 of 2022, on the file of the second additional principal judge, Family Court, Bangalore, seeking divorce. And the wife had filed criminal miscellaneous number 939 of 2022 before the Family Court at Mysore, seeking maintenance. Land counsel appearing for the petitioner, wife submits that after the disputes, she started residing at Mysore and she's working at Mysore. And
I nowhere admit that I am working, my lords. Actually, I am not working.
yeah, that she's staying along with the parents, working, remove that. And and the child is a differently abled child, and she has to take care of the child, and it's very difficult for her to travel all the way from Mysore to Bangalore and sought for the transfer. And so hence it is submitted that the MC may be transferred from Bangalore to Mysore. Next para. Land counsel appearing for the respondent husband submits that if the case is transferred from Bangalore to Mysore, it would cause lot of hardship to the respondent husband. He has to take care of his old age mother.
She's suffering from rapidly progressive renal failure.
She's suffering with the renal failure. And it
Acute
would cause a lot of
dependence.
hardship to him. It is submitted that the husband is ready to bear the expenses of the wife whenever she appears before the courts at Bangalore. It is submitted that he'll also cooperate for the speedy disposal of the case, and a time frame can be fixed for disposal of the case. Further, it is submitted that the wife is in a better financial position than the husband, and she is working and earning 40,000 per month, more
As
than
a
40,000.
teacher in Purna
40,000
Chetana
per
Public
month,
School.
and working as a teacher in a school at in Mysore. He submits that a time frame may be fixed to dispose of the pending MC, which is in the interest of both the parties. Next part. Having got the counsels on either side, produce the material on record. The admitted facts are the marriage has taken place at Mysore, and after the marriage, the parties were residing at Bangalore, and the wife, after the disputes, had left to Bangalore, left to Mysore, and the child is a differently able child, which is with the wife. But according to the husband, the wife need not take care of the child. In fact, her mother is taking care of the child. The case, it's an MC of 2022. The trial has not yet commenced, as the same is posted by the evidence of PW1. In the sixth trends, the trial has not commenced. Then counsel submits that for the respondent submits that if a time frame is fixed, they'll complete the trial. There are many other matters which are much older than this MC, and this court cannot fix a time frame and direct the court to give priority to this case. Then coming to the convenience of the parties, even if the husband, it is submitted that the mother is not well and he is working as a Zomato boy. And he is ready to pay the expenses of the wife. Now, looking at the financial aspect also, if he goes to Mysore, he doesn't have to pay anything to her. And at this stage, the court is concerned about the child who is with the mother. In that view of the matter, this court deems it appropriate to allow the CP. Accordingly, the court is passing the following order. The MC number 5241 of 2022, pending on the file of the second additional principal judge, Family Court, Bangalore, is withdrawn and transferred to the Family Court at Mysore. How many family courts are there at Mysore?
Not all, my lords.
You should say specifically.
There were about
Where
four
you s-
quotas.
Huh?
About 4 quotas there.
And then you have
It
to
may be
say
tagged along with criminal misnomer.
What, where, in which court it is?
Principal.
It is before the
Third additional principal,
Judge Family Court, one.
third additional principal.
Third additional principal Judge Family Court, Mysore.
To the third additional principal judge family court at Mysore.
And another case at the 7th additional senior civil judge and JMFC court at Mysore. It is dowry harassment case.
So that is nothing to do with
Please,
it.
madam, may make one submission, madam. Let the court may be done as early as possible to dispose of the matter.
No, please understand, if it is, if it's
If
such
it
a.
is not time
such-
frame, my lord, as early as possible, if it is. Let there be a good direction to cooperate the petitioner to conclude the proceedings.
Yes, next,
Otherwise, my lord, they will, if they seek time, my lord, then.
yes.
Let
Next,
there be a direction to cooperate with the proceedings.
yes, next. On the petition, the wife shall not seek unnecessary adjournments
Please.
and shall proceed with the matter.
Then number
Yes,
12, Chakravarti TS.
I am appearing for the petitioner, my lord.
Yes,
Yeah, seeking for the tank for petition Harihara to Davangere, my lord.
you are seeking from where to where?
Harihara to Davangere, my lord.
You are for the husband.
Husband of wife is residing in the Harihara, my lord. Husband is residing in the Vadalkere. Husband has filed the MC petition before the Vadalkere. Thereafter, present respondent has challenged this High Court. Transport petition is allowed by the Vadalkere to Harihara. But as per the High Court Order 2002 notification, Harihara and Davangere Revenue Taluk including comes under the Davangere Family Court, my lord. That's it, the jurisdiction not come the jurisdiction, and hence we are the file the present petition to Harihara to Davangere Family Court, my lord. Notification
What is
also
happening?
attached there.
When was this petition filed? On 9/12/2024?
Now is pending in an hearing and jurisdiction, my lord. Trial court.
Now, already an order is passed in transfer petition number 259 of 2017. If any.
Yes, my lord,
if that order
but,
has to be
there is-
reviewed. If that order has to
My
be
lord.
reviewed.
But it is the no
Notice-
jurisdiction come to that court, my lord.
That will be decided by this court by again another transfer petition. If the court has no jurisdiction, the trial court will decide.
Please, ma'am. But
Please
it is an trial court has said that liar, but you are approached the Honorable High Court, my lord. That's hence you are approached this Honorable High Court.
Please come. This transfer petition is filed, seeking transfer of MC number 27 of 2019 on the file of the senior civil judge and JMSC at Harihar to the jurisdiction court of at Family Court Davangere. The petitioner before this court is the husband. Husband has filed MC number 29 of 2017 on the file of the Senior Civil Judge and JMFC at Holal seeking divorce. The respondent wife had filed a transfer petition before this court, that is transfer petition number 259 of 2017, before the 259 of 2017. Then the matrimonial case was transferred from the Senior Civil Judge JMFC Holkare to Honorable to the Senior Civil Judge and JMFC at Harihar. Now, the present petition is filed seeking transfer from Harihar to Davangere. It is stated that as per notification number dated 26/7 to number Law 51 LSC 2002 dated 26/7/2002, the limits of Davangere and Harihar Revenue Taluk, including Davangere Town and Harihar Town, shall be the area within the jurisdiction of the family court. Davangere shall extend. It is stated that the matrimonial case jurisdiction comes under family court Davangere, hence the petition has to be transferred. Land Counsel submits that the court has already framed an issue with regard to the jurisdiction. He submits that the matter has to be dealt with by the family court at Davangere. The next part, this court earlier in transfer petition number 259, that CP number 259 of 2017, has already transferred the matter from JMFC Holekere to JMFC Harihar. On the grounds that are stated with the petitioner, this court is not able to understand, nor the court can appreciate the same. On considering the reasons, when a transfer petition is allowed by this court, the petitioner can, on whatsoever grounds, cannot file another transfer petition before this court and seek transfer of the same. And it is submitted that already an issue with regard to jurisdiction is framed and all these issues and this issue of transfer cannot be the relief that is sought by the petitioner cannot be decided by cannot be entertained by this court. Accordingly, the petition is dismissed.
Then number 13.
Yes.
Subramaniam.
For the petitions, please minutes. Not seeking transfer from Bangalore.
You're for the wife or the husband?
For the wife, please minutes.
From where to where?
From Bangalore to Mysore minutes.
When is the MC filed?
MC was filed on 11/12/2023.
11/12/2023. So,
I received
who
the
filed?
summons. I received the husbandman. I received the summons on 18/1/25.
18?
Not 18, my lords. 4/1/25 to appear on 18/1/25.
What are you doing there in Mysore?
Mysore, I am staying along with my parents, my lords, there. Earlier also, my lords, at page number 17 can be seen in the.
The present petition is for seeking transfer of the petition filed by the husband seeking divorce from Mysore, Bangalore to Mysore. It is stated that the wife is residing in Mysore and it will be difficult for her to travel all the way from Mysore to Bangalore, considering the same. They shall be stay of all further proceedings in
MC number. MC number
in MC number
675.
6754 of 2024. On the file of this, pending on the file of the third additional principal judge, family court at Bangalore till the next date of hearing. The petitioner is permitted to take the petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 25th of February, or else the stay granted by this court stands vacated.
25th of March.
Notice, in addition to this court notice.
25th of March, my lords. March, 25th of March.
Huh?
This month, March.
Yes.
Then
Yes,
number
next.
14.
My lordship, I am for the petitioner. Petitioner is the wife, my lordship. And she sought for transfer the petition from Asan to Bangalore, my lordship.
Asan to Bangalore.
Asan to Bangalore. My lordship, this petitioner,
when is the MC filed?
MC filed on 13/1/2025, my lordship.
What is the distance between both the places?
180 kilometers, more than 180 kilometers.
You are staying in Bangalore.
Bangalore, my
What are you doing in Bangalore?
She's working in Avali Technologies.
She filed MC for divorce.
MC petition filed on 26/10/2024, my lordship. After serving the summons, only to harass the petitioner, he has filed a restriction of conjugal rights petition before Asan, my lordship. And he is
You
a
filed MC for divorce in Bangalore.
Bangalore, my
You
lord.
know the MC that you are seeking
Ah,
transfer is,
my lordship. After receiving the
that I understood. I'm saying
Yes,
it
please.
is for restitution of conjugal rights. That is what you wanted to be transferred.
transfer to
Bangalore.
Bangalore. Yes, my lordship.
It is submitted that the wife has already filed MC number.
6655 of 2024.
So 24 seeking divorce,
6655, my lord, sorry.
seeking divorce on the file of the family court at Bangalore. After receiving the summons, the husband had filed MC number 16 of 2025, seeking restitution of conjugal rights at Hassan. It is submitted that the wife is working at Bangalore and it's difficult for her to travel all the way to Hassan, which is 180 kilometers from Bangalore. Considering the submissions, they shall be stay of all further proceedings in MC number 16 of 2025 till the next date of hearing. Next, for the petitioner shall serve the hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by same, what is the earlier date given, 25th? 25th, or it's the stay granted by this court stands vacated.
24/3.
25/3. List this matter on same date.
Please, my lord.
Next, earlier matter also on the 25th date itself. But if it is 25th, then give the next date. 25th, if they are asked to file the memo, list it on 26th. Yes, next.
Case number 15.
I appeal for petitioner, my lords.
Yes.
This petition is filed for the transfer of the MC case filed by the respondent, who is my husband. He has filed the MC case in.
From where to where?
From Chikmagalur to Chitradurga, my lord.
Chikmagalur to Chitradurga. What is the distance?
130 kilometers.
This is filed by the wife.
Yes.
When is the MC filed? Year.
2024, my lords.
When did you receive the notice?
Seven 12/2024, my lords.
Have you filed any cases at Chitradurga?
Yes, my lords. I have filed my MC case for conjugal rights. That is 173 of 24, my lords. And another.
One is prior, yours is prior or his case is prior?
I have filed.
Yours is the first case.
Yes, my lords. After my husband filed for the divorce, I have filed for the conjugal rights, my lords.
He filed at Chikmagalur.
Chikmagalur, Kadur.
The present petition is for seeking transfer of the MC filed by the husband seeking divorce from Chikmagalur to Chitradurga. Chitradurga.
Yes, ma'am.
Chitradurga, which is 130 kilometers away. It is submitted that the wife had filed MC seeking restitution of conjugal rights on the file of the family court at Chitradurga. It is difficult for the wife to travel all the way from Chitradurga to Chikmagalur. Considering the submissions, there shall be stay of all further proceedings in MC number
88 of 2024, my lords.
MC number 88 of 2024. On the file of senior civil judge JFC Court Kadu, Chikmagalur. Till the next date of hearing, same, the hand summons by 25th. Same, otherwise, list the matter on 26th.
Grateful.
Case number 16.
Speaking for the petitioner, my lord, wife petition, my lord, sought for transfer from Bangalore to Shimoga, my lord.
Bangalore to Shimoga,
Please, my lord.
distance?
Distance is 310 million kilometers.
310. When is the MC which year?
They 30/11/24, my lord. November 24th. I received no.
Filed any other cases at
No. She has 1.5 year month.
Shimoga to
Bangalore. I sought,
Bangalore.
no, my lord. She is in Shimoga, my lord.
Shimoga.
I sought for Bangalore to Shimoga, my lord.
It is
She has
submitted that
1.5
the husband has filed the
child,
MC
my lord.
seeking divorce.
Please, my lord.
at Bangalore and the wife is residing at Shimoga, the distance is 310 kilometers. Any other case there?
No, ma'am.
310 kilometers
They
and
have
very
1.5
difficult for the
year
wife to
child,
travel.
ma'am. 1 year, 2 months child, ma'am.
And she's having a child who is aged about, who is 1 year, 10 months.
2 months. ma'am.
2 months, and it's difficult for the wife to travel all the way from Shimoga to Bangalore. Considering the same, they shall be stay of all further proceedings. And further
742.
proceedings in MC number 7424 of 2024. On
Third
file of the
edition.
third edition, Principal Judge Family Court, Bangalore. Till the next date of hearing, same order is the only one.
Please, public.
Yes, next.
17, Sunil Kumar.
Two petitions filed by the wife seeking for transfer of two matters. One is not under section 144 of BNSS not seeking for maintenance, and the second one is not under the guardians and Warships Act not seeking to appoint her as the guardian of the second petitioner. Both petitions were filed by the wife itself, when she was in Chikmagalur. Later on, during fag end of the December and January of 2025, she shifted from Chikmagalur to Bangalore in search of job, and she has a 4-year-old child, that is the second petitioner. In view of that, she is finding it difficult to travel.
No. When are they filed? All those.
They are filed, order sheet at next year. It
In
was filed on
2024?
10th April, 10th April 2024. 10th April.
Husband is in there only.
He's there only, and
What is he doing?
maybe an agriculturist, right?
And where is the evidence to show that she is now doing a job here?
She's not doing any job, she's searching for a job.
Why did she come to Bangalore?
Not in search of job, and she has threat from the husband, when she'll be alone, in Chikmagalur, and she has a threat from the husband. That's why
She give any complaint?
there are no complaints. It's only
Just like that on vague grounds, we can't do it. If you want.
as of now, she's in Bangalore only. My lord, may kindly turn to page 30, page 30.
Do that.
The rent agreement.
No, not just like that coming here and staying. There should be some substantial reason. You filed a case at that place.
I only filed, my lord.
Then you
Now
come
she-
here. There should be some
she's
reason
facing
for
difficulty,
that.
my lord.
Just like that, you travel wherever and you want the transfer of the cases, it won't happen. You're saying one ground that you have a threat. For that, you should have given a complaint to the police. Second, you're so in search of a job. For that, what is the efforts that you're making?
But now, my lord, to travel from Bangalore, leaving, my lord, 4 years old child.
It should be there, just for the purpose of either harassing or whatever it is.
No, it's not harassing.
Reasons are not there, we will not transfer.
But she's not being paid any maintenance. She's a graduate, my lord, and in search of job, my lord, she
If
came.
you're not paid maintenance from a smaller town to a bigger place, you come and how will you sustain
No,
yourself?
that is only in search of job, my lord. That's why.
For that, while some material, then only we'll consider. When do you want?
Next week.
Next week? This is matter on 12th? Not 12th March. Yes.
Please.
Next.
Then number 18. Sunil Kumar B.
Same.
Then number 19.
No stay from 2022.
Please, my lord.
What has happened to the
My lord, the
Remanded
proceedings are
matter.
still pending and the records were also, my lord, secured.
Has it come yesterday?
No, my lord, this is the
No.
first. Previously, it was listed on 13/2. My lord, the plaintiff respondent number 1 filed a,
No, just wanted to know.
please,
What is the status of the case? When was the remand?
my lord, remand, my lord, the defendant number 2 filed an application for rejection of link.
Defendant filed for rejection of claim.
Application came to be allowed, plaint was rejected,
Hmm.
against which a regular appeal was filed.
Yes.
Thereafter, my lord, it was remanded back to the trial. After remand, my lord, the proceedings continued. Meanwhile, this appeal came to be filed. And now, my lord, evidence is yet to be recorded. Evidence is not yet been recorded.
2 years. You
My lord,
should have had a,
PS4.
you
Now,
should
my
have
lord,
had a stay.
only, my lord, So when the appeal was filed, I requested the court to pass some order. Court felt that, my lord, now matter is only being remanded. It takes some more time to record the evidence. Therefore, you can proceed with if it be feel
So
that there is
the
merits in the case, then
appellate court felt that rejection is bad.
rejection is bad. My lord, I'll just point out paragraph number 6 of the plaint. Only few lines.
Paragraph 6 of the,
6 of the plaint.
where is the plaint?
Plaint, my lord, trial court records are secured.
It's not in this.
It's there, it is secured, it is called for.
Yes. No, I'm saying it's not filed along with this.
It is not filed along with. Trial court
Yes,
records.
yes, record is there. It would be easy if you can file those documents so that we can complete it. Instead of again looking for each and every document.
My lord, I would not request your lordship to read all the documents, only the plaint our made.
So you just, before she takes that plaint, what is your case? Why is that plaint has to be rejected?
My lord, the case of the plaintiff was that, my lord, the scheduled property was granted in the name of defendant number 2 on behalf of the joint family. And subsequently, defendant number 2 had entered into a joint development agreement with the developer.
Your defendant number?
2.
Your defendant number 2.
Number 2.
Defendant number 1 is a family member.
1 is the mother.
1 is the mother.
Mother.
What is the suit for?
Suit for partition and declaration to declare that the release deed, my lord, on the date of execution of the joint development agreement, the other family members.
No. D1 was allotted when?
My lord, there is no partition.
No, D1.
Please.
You're saying that in the name of the.
D2. D2. My lord, so far as the grant is concerned, my lord, there is no dispute. 1982.
1982 is a grant in favor of the mother.
Brother, my lord, that is defendant number 2.
Defendant number 2. Then?
My lord, Kata was mutated in his name. My lord, the property was converted for non-agricultural purpose on 25/4/2012.
By the
defendant number 2. On 11/8/2014, he enters into a registered joint development agreement with the developer.
That is you.
Please.
That is D3.
D2. I am D2, man.
You are the brother. You are the one who have entered into the agreement.
Please.
You will enter into D3 with D3.
Not D3, my lord. That is developer is defendant number 18.
Defendant number 18.
18. On the very same day, defendant number 7 to 17
Who are the family members?
Family members executed a registered release deed, releasing all their right in favor of defendant number 2. Under the release deed.
That is dated?
11/8/2014. On the very same day, my lord, all the family members have received.
That is on 11/8/2014 is the date where D2 and D18 have entered into an agreement.
Please.
And on the same date, 7 to 17 have executed release date.
Release date. And in the plaint, it is alleged that as agreed under the release deed, the defendant number 2 did not pay the entire amount. Subsequently, he paid only ₹9 lakhs. And thereafter, he had assured we will pay the remaining amount. And also along with the remaining amount, he has promised to give 2 villas. He did not pay the remaining amount and did not give 2 villas.
Well, the relinquishment it is a conditional one.
There was no such condition. Your lordship may kindly, may I pass on, my lord, the release deed. In that there is a recital that, my lord, the plaintiff has received a sum of ₹15 lakhs by way of cash.
Because in that manner.
And there is no fraud alleged in the end.
Relinquishment deed cannot be registered like that with all these further conditions.
There is no such condition that the defendant number 2 would give her the remaining amount or promising her to.
So on that basis, they file a suit for partition and
Partition and declaration.
Cancellation of that
Release deed.
Release deed.
And in the plaint paragraph number 6, she further plaintiff alleges that there is a breach of contract. When there is an allegation is made that there is a breach of contract, whether a suit for partition would be maintainable. And without making any allegations of fraud, misrepresentation, coercion, whether the release date could be set aside.
But you have to look at the whole plaint and basing on one of these in a suit for partition.
Please.
What they say that it's a joint family property. Joint family property and they seek partition and all of that on the merits of it, the court has to decide.
My lord, now my lord, the plaintiff's entire cause of action is based on the release date. My lord, if there is an allegation of fraud, misrepresentation, coercion, undue influence are made, then it would have been.
Who filed the suit?
Suit is filed by the sister.
One of the only
One
is
only
the
one.
Then who is she? Like in the relinquishment deed, she's a part.
She is a party to the relinquishment.
You were saying defendants 7 to 17 have
7 to
executed
17 along with the plaintiff.
along with the plaintiff.
Plaintiff. My lord, the plaintiff is, my lord, releaser number 2 in the release.
Now we will go to the order passed in the RA.
My lord, your lordship, before my lords, I'll like to draw your lordship's attention to the order passed by the trial court.
Where is that?
My lord, it is on page number 41, my lord. That is the reasoning portion.
Yes, please read.
In order to appreciate the case of the plaintiff, it is necessary to refer the pleadings of the plaintiff at para number 6. The plaintiff is not disputing the execution of release deed in favor of second defendant on 11/8/2014. The plaintiff in the pleadings categorically stated that she had executed the release deed in favor of second defendant, and the second defendant has agreed to pay a sum of ₹15 lakhs, but the second defendant not paid the entire amount as agreed by him. When the plaintiff questioned the second defendant has given only ₹9 lakhs, and he has agreed to pay balance amount after 3 months' time with the 2 villas. When the plaintiff approached the second defendant in the month of December 2014, the defendant in collusion with each other refused the right of the plaintiff, either claiming balance amount or property. According to plaintiff, at para number 6 of the plaint, there was a breach of contract between the plaintiff and defendant number 2. From the pleadings of the plaintiff, it could be seen that there is
This
a breach of
finding
contract.
itself is bad by the for trial court. Nowhere in the pleadings the plaintiff has stated as to how the release deed is illegal and not binding. Why all the things will be?
My lord.
Is it?
My lord, in law, my lord, if a party executes a deed, release deed or any sale deed, conveyance, my lord, if a cancellation is sought, a cancellation can be sought only on the grounds available, legally available grounds. Mere fact of filing a suit without
Not granting, not giving the amount as stated in the release deed is also a fraud that is played. No, not in so many words.
at least a word of fraud with detail.
That is
My lord, that
too
is the requirement
technical.
under CPC.
No, that's too technical.
That is the requirement under CPC, that if a fraud is alleged, details with the dates, everything should be mentioned. And in the further plaint, it is alleged that, my lord, there is a breach of contract.
The plaintiff pleaded that she was taken to sub-registrar's office forcibly and out of so-and-so on threat, they got obtained the signature of, this is not binding, and over the plaintiff, so this should have been pleaded according to the court.
There is nothing like that.
If we have to decide all the cases in
My lord.
this manner, then
My lord,
no
I
civil
would-
case
I would
can be looked into.
Request your lordship to only to look into the the averments mentioned in the plaint where the plaintiff alleges that there is a breach of contract. For a breach of contract, whether a suit for partition, whether she has a cause of action, whether the cause of action mentioned by her is imaginary and the suit is vexatious.
That's one of the paragraphs she has stated, so.
Nothing is said. Kindly look into the plaint averments. Only paragraph number 6, where she.
Please come to the appellate court, sir. Come to the reasoning of the appellate court.
Lord, reasoning of the trial court order, my lord.
No, appellate court.
Appellate, please.
I've seen the reasoning of the trial.
Please. Page number 27, my lord.
Para 12, shall we read from para 12?
Please.
Yes.
The averments of the plaint
Yes.
are that the plaintiff's father owned property bearing survey number 17, measuring 3 acres, 1 guntas, including 3 guntas of Karab situated at Sigehalli village, Vidarhalli Obli, Bangalore East Taluk. The plaintiff and defendant number 1, 2, 7, 8, 9, 10, and 14 are the children of Chikkapaya. Defendant number 3 to 6 are the legal representatives of second defendant. Defendant number 11 to 13 are the LRs of the 10th defendant. Defendant number 15 to 17 are the LRs of 14th defendant. They are grandchildren of Chikkapaya. Genealogical tree is produced. Chikkapaya filed an application for granting tenancy rights before the land tribunal. When the proceedings were pending, Chikkapaya died. After his demise, the land was granted to second defendant as he was elder male member of the family in the year 1992. And after grant of revenue entries, the entries were effected in the name of second defendant as per MR number 13/8384. The grant was in the year 1982, but it is wrongly mentioned as 90. They are in joint possession and enjoyment of the suit property. These averments do not say that the suit property is an ancestral property of the plaintiff and defendant. It is not mentioned in para 125 that the suit property is an ancestral or joint family property. It is further averred in the plain that the second defendant got converted the land out of total extent of 2 acres 39 gundas for non-agricultural residential purposes as per order dated 25/4/2012. In the meantime, second defendant has executed joint development agreement in favor of 18th defendant along with defendant number 3 to 6. It is registered in the office of Sub-Registrar Shivajinagar. On the same day, a release deed is got registered from defendant number 77 to 17 and plaintiff, wherein the second defendant has agreed to pay a sum of rupees 15 lakhs to the plaintiff and other defendant. It is further agreed to pay balance amount within 3 months with the 2 villas. There is breach of this contract. Looking to these pleadings, the trial court has formed an opinion that the plaintiff should have filed a suit for specific performance of the contract and not the suit for partition, because there is no privity of contract between the plaintiff and defendant number 18. The certified copy of the release deed is on record. It is executed by plaintiff also. In this release deed, it is mentioned that they have relinquished right, title, and interest over the scheduled property. The releasee has paid a sum of rupees 15 lakhs to Sri Chandrasekhar by way of cash. The releasee has paid rupees 15 lakhs to Krishnamma by way of cash. If we go by contents of release deed, plaintiff has received entire rupees 15 lakhs from defendant number 2. But it is the case of plaintiff that only 9 lakhs rupees were paid to her. In the release deed, though it is mentioned that releasers acknowledged the receipt of the same, there is no mention that the separate receipt is not required. Be that as it may, joint development agreement is between defendant number 2, C. Anjanappa, and his sons and daughters and Geetanjali developers. The plaintiff is alleging that under the false promise of giving 2 villas and rupees 15 lakhs, she has signed the document. That is to be inquired by the trial court. A fraud vitiates the entire proceedings. When fraud is alleged, the trial court should have permitted the plaintiffs to lead evidence. It is further case of the plaintiff that the land was a tenant and land. Her father was a tenant. He had applied for granting occupancy rights. But when the application was pending, her father died. In other words, the property is self-acquired property of her father. By interstate succession, it has fallen in the hands of successors. This aspect is important because a succession under Section 6 of the Hindu Succession Act does not open. The plaintiff cannot challenge those allegations, etc. But the case is not so. Section 91 and 92 of the Indian Evidence Act are very clear that the plaintiff can question the validity of release deed, which is stated to be executed under a false promise. In para 10 of the plaintiff, it is pleaded that the cause of action for the suit has arisen on 8/11/2014 and subsequent in the last week of April 2015, when the plaintiff conveyed panchayat, and subsequently on 7/5/2015, when the plaintiff approached the local police, etc. But the main date of cause of action is 8/11/2014. On 8/11/2014, when a relinquishment deed is executed by the plaintiff under a false promise of giving 15 lakh, therefore the trial court ought to have framed proper issues, and it ought to have provided an opportunity of leading evidence and then to decide the case on merits. There is delay of 20 days in filing the appeal. However, when the merits warrant, the delay may be condoned imposing proper cost. This regular appeal is pending since 2017 before this court. By this time on merit, the suit would have been disposed. Therefore, even when case is remanded to the trial court, costs are to be imposed on the appellant plaintiff. For these reasons, point number 1 and 2 are answered in the affirmative, and point number 3 in the negative, and point number 4 is answered in the affirmative. My lord, if the plaintiff had contended on the date of execution of the release deed, he had promised to give 2 villas on the wrong
According to the court, you might be having a good case on the merits of it. Not a case
Lord,
for,
where an allegation is made without, Your Lordship may kindly for a moment, kindly permit me to read the para 6 of the claim. Entire crux of the case.
yes.
When such being the facts, the second defendant got conversion order in respect of 2 acres 39 guttas out of total extent converted from agriculture to non-agriculture residential purpose as per order dated 25/4/2012. In meantime, the second defendant has executed joint development agreement in favor of 18th defendant along with defendant number 3 to 6, which is duly registered in the office of sub-registrar dated 11/8/2014. On same day, the second defendant got registered release deed from defendant number 7 to 17 along with the plaintiff by saying that the second defendant agreed to pay rupees 15 lakhs to the defendant number 7, 8, 9, 10 and 14 along with the plaintiff. But the second defendant is not paid the amount as agreed by him. When the plaintiff questioned the same, he has given only rupees 9 lakhs. Further, he is agreed to pay balance amount after 3 months' time with the 2 villas. Again, when the plaintiff was approached in the month of December 2014, on that time, the defendants are all in collusive manner with each other. They are totally refused to right of the plaintiff either claiming balance amount or property, even though the plaintiff is entitled for equal share over the scheduled property. Thereby being the aggrieved by the defendants illegal activities, the plaintiff conveyed the panchayat in the locality in the month of April last week, 2015. In the panchayat also, the defendants not heeded the voice of the plaintiff or the panchayatar. When the second defendant not stand his words with the plaintiff, there was a breach of contract between the plaintiff and defendant number 2. Thereby, the plaintiff lodged a complaint before the jurisdictional police station on 7/5/2015. In turn, the concerned police have advised the plaintiff to approach the civil court as the matter is civil in nature. Thereby, without finding any other alternative, the plaintiff approached this honorable court with the suit for partition and separate possession, declaring the alleged release deed and joint development agreement dated 11/8/2014 is null and void and it's not binding on the plaintiff's share. When there was a breach of contract, Your Lordship may continue. When there was a breach of contract, the alleged release deed is to be cancelled. When it can be cancelled, the plaintiff entitled for a share over the scheduled property. Does not even make an allegation. Now, my lord, what are the averments made? My lord, Your Lordship may kindly look into the release date, which is on record. Release date dated 11/8/2014. Not executed. 2014. 14. Lord, the first part is Krishnama, second releaser is Lakshmama, that is the plaintiff.
This was filed by them before the trial court along with the plaint.
It appears, my lord, it is filed along with the plaintiff.
Look at the plaint. Here it is.
In para 6, there is an allegation that, my lord, with regard to.
No, one more aspect is, if the release deed is not filed along with it, how do we look at the contents of that release deed while deciding an application under Order 7 to 11?
My lord, documents referred in the plaint.
Not only
Lord,
referred, which are filed.
My lord, produced along with the plaint
That's
and
what-
referred in the plaint.
Correct, produced in the plaint.
Produced along with the plaint and referred in the plaint can be looked into.
They might have referred. They have to be there. They should be there on the record on,
My lord,
when the court has.
That's what the
looked
apex
into it.
court, my lord, says, the documents produced along with the plaint and referred in the pleadings.
That should have been on record by that time for the court to look into.
I think it is on.
It
should be there.
appears it is not from the plaintiff. If you want the matter to be adjourned, I can adjourn the matter, but.
Lord, I am not seeking any adjournment.
No, you're not seeking. I'm telling you can, if you want to place any judgment, I'm not inclined. I'm inclined to dismiss it.
Well, I would like to persuade my lord.
Yes.
I would like to persuade my lord by placing reliance on certain judgments.
When?
Then I'll leave it.
Yes.
Because keeping pending, my lord, this matter.
It's already like 2022, we are in 2025. No, the trial must be going on there.
No, my lord, the records are here in this file. Records are before this court.
That's why.
And my lord, any amount of, my lord, evidence without pleading,
No,
my lord, nothing but
even in RA, the court was saying by this time, the entire suit would have been disposed of.
suit could have been
The same
disposed.
thing would have happened
Whether-
even
Lord,
with this also.
where a party has no cause of action, whether such suit could be entertained. My lord,
That's what, by that time you
in
would
and
have
around Bangalore,
you would have had a positive relief in your
my lord,
favor.
in and around Bangalore, my lord, there due to escalation of prices, my lord, the family members, my
that
lord,
is
time and
true.
again is happening.
Whenever it's a case, court would definitely consider, nobody can be permitted to abuse the process. But the thing is, if this kind of strictly, if you have to look at every plaintiff, majority of the cases has to go.
My lord, if there is an allegation of fraud, my lord, if the contents are contrary to the, my lord,
Sum and
release-
substance of it is that.
my lord, it is entire
That
pleadings.
he has not paid the money and got it, something like that.
My lord,
Something like that.
the allegation is that under the release deed, money was not paid. Which is contrary to the, my lord, the release deed. In the release deed, it says, we acknowledge the receipt of the money.
No, you will have
When
that.
it is a registered
You
instrument,
will have the advantage of the lapses on the part of the plaintiff in pleading all the relevant aspects.
my lord, lapses
the-
could be, my lord, any lapse on the part of the plaintiff could enable to the benefit of the plaintiff where they have should have sought all those required, my lord. And in the case of registered instrument, where now they are seeking for declaration, where the other family members were also party, they have not approached the court. They are made as defendants.
What was,
And-
have they filed their written statements?
My lord, it appears defendant number 2 has filed written statement.
Sailing with plaintiff?
My lord, defendant number 2 is not sailing with
You
you.
are the defendant number 2.
I'm the defendant.
No, I'm saying other defendants. who have
Other
executed
defendants,
the
my
deed.
lord, defendant number 2 to 6 together have filed.
So they're sailing with the plaintiff?
No, they are not sailing with the plaintiff.
What do they say?
They, my lord, their silence would, my lord, admit the execution of release date.
You can place the judgments when?
Please, my lord. 2:30, my lord.
2:30, yes, 2:30.
2:30.
Awesome.
Or my lord may be taken up tomorrow.
Tomorrow. Tomorrow more matters are there, I think. Day after?
They are,
Yeah.
please, much.
Yes. Get the. Probably what has happened? Huh? Hmm. This is 228. When you're saying something, if any objections are raised, you should say that it is for so and so, so that he'll get they will have knowledge, I mean, they'll understand what's your objection and they can comply the objection. Section 228. Their objection with regard to.
I think the section 228.
228, that is there,
The section 228 is clear.
It is only in respect of a will. This is a letter of administration because the person has died intestate. What does
It
228
says
say?
a letter of
The 228 says that a will
has been proved
If it
and
is proved
deposited in a court of competent jurisdiction situated beyond the limits of the state,
yes,
within or
that
beyond the
can be
limits.
produced. A copy of that can be produced, and on the basis of that, a letter of administration can be. Here, this is not a case of a will having been proved abroad. Here, this is a case where I'm working here in India. By virtue of my terms of employment, I am entitled to certain stock options, which my company in India has given me in the parent company in USA. Now, I can't, the letter of administration is applicable only within the territorial confines of India. I cannot take this and lay claim, I cannot take this and obtain a transfer of those shares in my name there. The reason I'm seeking a letter of administration is I'm going to give this letter of administration to my husband's employer here. He will then forward it to the US and that will be monetized and that money will come into my account.
We'll hear it day after tomorrow. Yes.
My lord, I have compiled all
Yeah,
the
sure.
office objections.
Oh.
Answer the case.
Oh.
From Alur Rasan to Bangalore, the petitioner,
Please.
On 7th edition. Obliged.
Ladyship, may I make a mention regarding a passed over matter, Your Ladyship? Serial number 3, the respondent had got the matter passed over to seek instructions from the client. I'm informed that they have.
Yes, my lord. I've received instructions from a client as requested by them. Both the parties can meet this honorable court in person, my lord. And we've decided on the date that is the 14th, my lord. This Friday, both the parties, my lord.
Friday is not possible. Friday, is not- any other day, but not Friday.
I have no objection to any date subject to the convenience of the
Yes, my lord.
Get instructions. Friday is not possible. Ask her for any other day.
After,
Report after lunch,
All right, ma'am.
after lunch.
much obliged.
What up, sir?
ಹೇಳಿ ಸರ್.
What up, sir?
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಒನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಏನಾಯ್ತು? ನಮ್ಮ ಇಂಟರ್ನೆಟ್ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಇತ್ತು.
ಅದೇ ಮೇಡಮ್ ವೆಯ್ಟ್ ಮಾಡಿದ್ರು, ನೀವು ಕರೆದು ಸಾಕಾಯ್ತು, ಆಮೇಲೆ ನೀವು ರೆಸ್ಪಾಂಡ್ ಮಾಡಿಲ್ಲ. ಅದು 11 ಒಂದ್ ನಿಮಿಷ.
ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಮೇಡಮ್.
ಅದೇನಾಗಿದೆ
ಯಾವತ್ತಿಗೆ?
ಸರ್? ನೋ
ಹಲೋ
ರೆಪ್ರೆಸೆಂಟೇಟಿವ್. ಹಲೋ ಸರ್.
ಎಷ್ಟೊತ್ತಿಗೆ?
ಮಂಡೇಗೆ ಫಾರ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಆನ್ ಮಂಡೇ. ಡಿಸ್ಮಿಸಲ್ ಕ್ಯಾಪ್ಷನ್ ಅಲ್ಲಿ ಸೋಮವಾರಕ್ಕೆ ಬರುತ್ತೆ, ಅವತ್ತು ಅಟೆಂಡ್ ಮಾಡ್ಬಿಡಿ.
ಓಕೆ ಓಕೆ. ಸ್ವಲ್ಪ ಇಂಟರ್ನೆಟ್ ಪ್ರಾಬ್ಲಮ್ ಮಾಡಿ ಏನ್ ಮಾಡೋದು ಇದು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ನನಗೆ.
ಆಮೇಲೆ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಜಾಸ್ತಿ ಸರ್. ನಿಮ್ದು ಆಫೀಸ್ ಇದು ಸುತ್ತಮುತ್ತ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಮೇಡಮ್ ಎಸ್ಟರ್ಡೇ ಆಲ್ಸೋ ಯು ಓನ್ಲಿ ಮ್ಯೂಟ್ ಅಂತ ಹೇಳಿ ಮ್ಯೂಟ್ ಮಾಡಿಸಿದ್ರು. ಅದು ಎರಡು ಕನೆಕ್ಟ್ ಆಗ್ಬಿಡ್ತೀರಾ ನೀವು?
ಇಲ್ಲ, ಅದು ಒಂದೊಂದು ಈ ಕನೆಕ್ಟ್ ಅಂದ್ರೆ ಎರಡು ಕಡೆ ನೋಡ್ಕೊಳಕ್ಕೆ ಏನ್ ಮಾಡಿರ್ತೀವಿ, ಮ್ಯೂಟ್ ಮಾಡಿರುತ್ತೆ.
ಆಯ್ತು.
ಆಯ್ತು ಮೇಡಮ್, ಓಕೆ.
ಓಕೆ ಸರ್, ಓಕೆ, ಮಂಡೇ ಅಟೆಂಡ್ ಮಾಡಿ.
ಥರ್ಡ್ ಲಿಸ್ಟ್ ಯಾವಾಗ ರೀಚ್ ಆಗ್ಬೋದು ಮೇಡಮ್?
ಇವಾಗ ಕರಿತೀನಿ 2:30ಗೆ.
ಓಕೆ.
Lordships, I'm appearing for the petitioner in CP 96 of 2025. The Lordships may recall yesterday this Honorable Court had directed the arrest of a vessel. Yesterday, pursuant to the discussions, the matter has been settled. I may be permitted to withdraw the petition. Pursuant to the
Why
arrest order.
After passing the
Yes,
order of arrest.
pursuant to
it is
the parties, they have settled the claims. I may be permitted to withdraw it.
settled. Just to come, that time, we'll have it tomorrow.
Well, it's end of the list. The concern is there are detention charges which might be incurred on the vessel. So it might open up.
Everything is urgent. Your lunch motion is urgent, your withdrawal is urgent.
I understand.
And no other work the court has.
So my humble request, that's all. By the end of the list, it will.
Yes,
With your lordship's leave, my lord.
yes.
List number 3, my lord, I have to go for a medical checkup, my lord. I request serial number 1, 2, 3, 1, 2, 7 and 11 may be taken up day after tomorrow, my lord. List number 3, serial number 1, 2, 7 and 11.
My lords, on submission, my lords. List number 3, serial number 2, I am for respondent number 2, my lord. Respondent number 2. My lords, and also I am not filed Okalat in this case, my lord, because I am appointed as legal aid counsel in this
All
case.
these matters till 11, 1, 2, 7 and 11. These matters on.
In serial number 2, my lord, the copies have been filed in the counter for her to collect.
20th month.
My lords, one day I have received a memorandum of appeal copy, my lords, and judgment I have not yet received. They have not served a judgment.
He says yes, sir.
As directed by the court, my lord, I have filed it in the counter. She has to collect it from the.
My lords, only memorandum of appeal.
He says he filed in the counter.
I checked it, my lords.
There's a court order. Yes.
Only memorandum of appeal is there, my lords. There's no judgment copy.
In all the matters, either to serve or Mr. Mahesh to serve on, or the papers to be served on him, some the representations of this nature are going on. I don't know what is happening. You say you have given, she says only memorandum is given.
Yeah, memorandum, my lord, that was, my lord, the order was there. Appeal memorandum has been given. She is legal services authority, my lord. Earlier she said that she is not there, then later she accepted it. And as per the court order, my lord, I have filed it into the counter. Appeal memo.
But there is no judgment copy in this, my lords. I have received it in pending, my lords.
That she has to get it from the legal services authority.
I asked it there also, my lords. They told me to get in pending. That's why I received in pending, my lord.
Yes, next. Yes.
Pass over matters in the 1, serial number 3. Pass over matters, serial number 3.
Explain to the respondent. Earlier, we had to decide on a date for the parties to interact with you in person, my lord.
Anything is okay with
12th.
them. Let's just matter on 12th of March, on the day, both the father and mother, along with the daughter.
No, my lord. They have only requested for just the parties, not the kids, my lord.
It is not their request.
My lord, in that, understood, my lord. In that scenario, my lord, both the kids may be asked to come to court, my lord. And
Yes, both the kids,
my lord,
along with the mother and father shall be present.
my lord, I'm sorry, my lord. Based on the submission, we have suggested on 12th as the date. Since it's a working day for them in the rest of the week, my lord, are them traveling?
For the kids, if Saturday is a holiday, court will not sit.
Friday is better, my lord, because whatever it is, after Friday, they can settle down.
I'm really not happy with all these requests. This is, you have to, I said Friday is not comfortable to the court.
Understood, my lord. But the week after that, my lord, the third week, if it accommodates this honorable court.
The senior will come. Where is the senior?
My lord, senior still held up, my lord. That is why I have come before this honorable court. For
They have to come. Doing no more this thing on this. This is matter on 12th of March, on the day at 5 p.m. in the chambers. Both the mother and father, along with the kids, shall be present. Yes. Next, call the next matter.
Serial number 15.
My lord, I request to allow the IA number one,
Hmm?
1 of 2016, which has been copy is also given to them, my lord. It has already applied in 2016 itself. They have
IA
not,
number 1 of 16 is filed to condone the delay of 2152 days in filing the appeal. Both in the forenoon and the afternoon, there is no representation on behalf of the respondent insurance company. List this matter day after tomorrow.
much obliged.
Yes, next.
Serial number, which number 3, serial number, which number 2, serial number 6.
And for the
Yeah.
petitioner,
Yes.
we have complained the office objection. This is a transfer case from Alur, Asan to Bangalore. The petitioner number 1 is a 70 years old
Hmm.
and undergoing treatment both in Astra CMI hospital as well as Kottakkal. I have produced the documents. She's undergoing the treatment. She's just 70 years. And she has sold the property to petition number 2, located in Alur Taluk, Asan district. And the caretaker, watchman, has filed an OS suit falsely against these two people. So both of them are ladies. The second one also 55 years old. So we are requesting to transfer the case from Alur to Bangalore so that it is convenient. The first petitioner cannot even travel. She's on the wheelchair. So that's a submission I'm making to transfer this case from Alur, Asan to Bangalore, which is around 225 kilometers. It is the case came up on
Also age 60 years.
no, 70 years. For petitioner 1.
Plaintiff is 60 years.
Yeah, 50 years.
He is also comes within the bracket.
No, she's a lady and she's a widow actually. That's another problem, my lord. Both of them are ladies and there is no cause of action. First lady is the owner of the property and sold it to second, this one. And unnecessary OS suit has been raised to harass them.
What issue notice in this?
No,
Court notice on the council. We'll
no.
hear it.
Yeah, counsel, okay, transfer the case. Meanwhile, stay on the proceedings.
Which year is this suit?
Huh?
Suit is of which year?
24. This is filed on 12/24.
No, is this the ground to transfer?
This is December 2024 they have filed.
No, it's not that. The respondent is also a senior citizen.
No, third respondent is not a senior citizen. He is 60 years. He is well built actually.
No. Whether he's well built or
The main,
is weak, 60 years is a senior citizen.
yeah, that as per, but
What the law says.
my submission, my lord, the first one is,
Happens is civil matters on these grounds cannot be transferred.
no, the request is that these two are ladies. They cannot travel 225 kilometers.
Not a family matter.
No, I do agree. But even they have,
Family matter, the matters are, the suits are filed as per the jurisdiction.
I
of the court.
absolutely, you are right.
So if in every case, because the party is 60 years old, 70 years old, if the court starts transferring it, there is no.
Your Honor, you look at the Annexure A, page 10, she's continuously undergoing treatment in the hospital. And even for evidence or anything, once the
Further, then give a GPA to somebody. Somebody will
no,
represent.
there is
you.
nobody there. That is the whole
Not
problem.
there. The person who is here, your close kith and kin, you give them, they will go.
No,
to your
there is
side.
no.
You don't have children.
The problem is, children are all in abroad. My
We can't.
No, my submission, Your Honor, this is a case.
That's what I'm saying. At best, the court will grant only, will permit you to take out notice, no stay.
Notice for, till such time stay can be granted till the transfer.
We'll have it next week.
Oh, that's okay. I will serve the.
And then when Master come, then we will decide finally. Learn counsel for the petition is permitted to take out notice on the counsel appearing for the respondent before the trial court and file a memo to that effect by 14th March.
It's okay.
By 14th March.
No.
If the memo is filed.
Not 14th, give me 20th because somebody has to go there.
20th, hand summons, 20th. List
To the counsel of the.
If the memo is filed to that effect, list this matter on 25th.
Meanwhile, stay on this proceedings of this, my lord.
When is the
No.
case coming up before the trial court?
This is on 7th or 8th of April it is coming. It has come up earlier once in February. Nobody attended.
A date.
Huh?
What is there should be a date for that. What is the date?
Date is 15/4.
Huh?
15/4.
So there is long way. I'm posting this matter in March itself.
Oh,
Yes, yes.
20,
Page number
20.
3,
much obliged, sir.
serial number 1 and 2, adjourned, serial number 3.
My lord, small request. Can I take the hand someone's in a day or two, because distance is there, that's the reason.
And someone's?
Taken up in a day or two,
I didn't get it.
unless someone, little early.
It will, they will do it, but tomorrow it will.
Oh, acha.
Yes.
Number 3, serial number 3.
For the
Objection.
appellant, my lord.
Appellant.
Lord, I have to file English translation of the volume of document. I may kindly be given time, my lord.
What translation? Which is a document?
My lord, judge, all the judge papers are in Kannada, my lord.
No,
I
no,
wanted to
it's a
file.
claimant's appeal.
Huh?
It's a claimant's appeal for
No,
enhancement.
no. It is insurance appeal
Insurance companies,
challenging the liability, my lord, on the ground that on the date of the accident, he had no DL, my lord. I examined the art.
that's simple. If that is it, why we want all the translated copies? It is a MFA of 2013. I have no intention to adjourn any of the matters of 2013.
Lordship, kindly have it. I will. Only thing is, I will. I wanted to read.
No, if the
the
DL
evidence of the RTO. I have examined the RTO. Kindly take it up next week or any other day.
you can read the that Kannada version itself and tell
I will
the
read it, my lord. Kindly accommodate today, my lord.
and will not be adjourned further.
No, madam. If your lordship
Be
is
at the request
comfortable
of
with
Lord
Kannada,
Counsel for the petitioner.
I will not take more than 5 minutes.
This matter on 11 because it's a simple matter.
It's a
Hardly
simple matter, madam.
2 minutes for you, 2 minutes for him, and 3 minutes for me to dictate.
Okay.
Yes.
Serial number 4,
Date, madam.
the 11-3.
Yes, is next.
4, Mahesh BJ. For
I'm for-
appellant B Pradeep.
Appealing for appellant, my lord. It's a 1 year appeal, my lord.
You are representing Pradeep.
No, ma'am.
BJ Mahesh, I'm representing.
I'm for claimant.
Pradeep and S.
Pradeep is
Maheshwara.
representing the insurance company. My liability is
BJ
fixed
Mahesh,
on the
my lord.
owner.
Appellant.
No, I understand that. I'm asking for respondent who is appearing.
But Pradeep has to appear for the insurance company. Now, my lord,
Not to be seen.
Morning session here.
Martin is there, my lord.
He was here only. Morning session.
Inform him, we'll call. You are ready? I inform him and we'll call next. Yes, next.
Number 5, Suresham Latur for appellant.
Yes, Mr.
I am
Rathur.
for the appellant, my lord.
Nandi Shivanand.
Yes,
You appear for the respondent.
yes.
My lord, claim petition has been dismissed. It is a claimant's appeal, my lord.
166 or 163A?
166.
On what ground it is dismissed?
There is a change in the number, my lord.
Please
The
come to the,
K04EA 9558 is the vehicle number,
come
my
to the
lord.
reasoning part and read para number 18.
File number 18, my lord. Para number 8, my lord.
Yes.
Para number 8 of the page 4, regions. May I read it?
Yes.
It is the evidence of PW1 petitioner that on 11/3/2009 at about 8:30 p.m., when he was crossing the road carrying a box which was loaded with skin of sugar cane from south to north direction. At that time, a rider of motorcycle bearing number K04 EA 9558 came from west to east direction with high speed in a rash and negligent manner and dashed against him, as a result of which he sustained the grievous injuries and took a treatment in the hospital and spent a lot of money for his treatment. In support of his said contentions, he relied on the police records
records such as police notice, CC of FIR, charge sheet, Mahajar, sketch, wound certificate, and discharge summary, which are marked as Exhibit P1 to P6 respectively. Apart from the oral evidence, the petitioner has produced a copy of FIR Exhibit P1 and copy of Mahajar Exhibit P3. Both documents clearly shows that KR Puram Traffic Police have registered a case against the driver of a motorcycle bearing number K04EH9558 for the offence punishable under section 279-337 of IPC. Exhibit P5, wound certificate relating to the petitioner in which the doctor has stated that the petitioner had sustained injuries in a road traffic accident. After investigation, the police have filed the charge sheet as per Exhibit P2 for the offences punishable under section 279-338 of IPC against the driver of the motorcycle bearing number K04EH9558. The registration of a criminal case and filing of a charge sheet prima facie establishes negligence on the part of the driver of the offending vehicle number K04EH9558. The respondent number 2 filed the written statement and denied the petition of amendments.
Yes, Mr. Lathur, I've seen. What are your submissions?
Yes, my lord. In this case, my lord, it was admitted fact. It was admitted fact that the vehicle has been, the vehicle number is so little bit, there is a change in the number, my lord. That is K04EA9558 is the actual number as per the registration records, my lord. But here it has come that K0EH9558 has come. It has been even in police records, even in the evidence, even in the petition also, the petitioner has filed that it is K04EH9558, my lord. EH9558. Now, my lord, here the Honorable Tribunal has dismissed the claim petition saying that K04EH9558 has not involved in the accident because the registration number is K04 EA9558 is the vehicle involved in the accident. So here, my lord, my humble submission that even that it is an admitted fact that the accident has been admitted by the respondents. That even the insurance company has admitted in their objection petition also. Even in cross also not denied it. But subsequently later on the insurance company has produced the RC book. Then it came to know that to the insurance company also that vehicle number is, there is a little bit change. RC has been produced. Now, my lord, here my humble submission. Xerox copy of the insurance policy I have produced for the court, my lord.
We'll ask her. Yes,
that is serial number 7. Serial number 7. Copy of the policy has not been produced by the insurance company in this case, my lord. But I have produced.
We'll ask her.
My lord, in the first instance, they filed the claim petition claiming that motorcycle bearing registration number, only that EH is the difference, my lord. First, in the initial state, they filed it as EH was involved in the accident. Then later, after we led evidence and showed that it is EA, then later they changed the vehicle number.
No, at any point of
they
time.
filed an amendment application and changed the vehicle number, stating that EA was involved in the accident.
1 minute. At any
1 minute,
point
yes.
of time, is it the case of the insurance company that that there was no accident?
No, my lord, we admit the accident. There is no
You admit no
dispute regarding
either of-
that.
No, only it is a typographical mistake in mentioning the number. We have to take it like that. Vehicle is involved in the accident. Just because
Yes.
that one A instead of mentioning A, they have mentioned H. For that
Yes.
reason, the court cannot completely dismiss the petition.
My lord, here in this case, EH is insured, not EA is not insured.
But ultimately, you know
Our
that EH is the one,
contention
EH is the one which is
is
involved in the
EH
accident.
is the one that is insured.
No, that is the one which is involved in the accident also.
No, what they filed the amendment applications later stating that it is EA that is involved in the accident.
Yes.
They only filed it.
So who is denying that EA is not involved in the accident?
Lord, we are not denying it. We are just saying that EA is not involved in the accident. It is EH that we have insured. Our main contention is that EH is insured, EA is not insured.
EA is not insured.
If they said that if EA is involved in the accident, as per their claim petition, later after the amendment, they amended it first in the initial stage. They said that EH was involved in the accident. Then later they filed an amendment application saying that it is EA that is involved in the accident.
No, there are two vehicles, EA, EH.
EH, yes, ma'am.
Said it is EH.
EH is insured, EA is not insured.
According to you, which vehicle is involved in the accident?
Milord, that they have to say, Milord, which vehicle is involved.
No, but you are not denying it anywhere.
We are not denying the accident. We are denying which vehicle is involved in the accident, whether it is EH or EA. That is the main thing, Milord, in this.
Owner name is same, my lord, in both the contentions.
No, you have given
the engine number is also the same.
You have given a complaint, and
yes,
and you have and what else? And you were admitted in the hospital.
Reports are against
there
EH.
also there is a number.
Milord, one submission. All the police records are against EH. Then later they made an amendment application stating that it is EA. In the claim petition, they amended it as EA.
No, EA is insured or not?
EA is not insured. It is EH that is insured.
My lord, it is admitted by them itself. RW1 cross-examination may kindly be seen. RW1 cross-examination, in which the insurance officer has admitted.
Is insured.
That is not the finding of the court at all.
The finding of the court is that it is whether it is EA or
Only
EH.
on that, whether it is EA or EH, because in all the records it is EH, but not EA.
But they amended the petition to EA, then later they amended it.
They have amended it based on your pleadings.
EA was involved in the accident.
My lord, it is their instance since we have amended it. They have taken the contention that by producing RC, owner is same, my lord, but EA is the vehicle involved in the accident. It has been their contention, insurance company.
When you have filed a petition under 166, the burden lies on you. No, just like that, by amending the number from that to this, you cannot prove it. You have to prove it by some cogent evidence. What is the evidence in support of an accident? Either the complaint or whatever is the record, the medical records, the complaint, or some oral evidence. What did you do?
My lord, here I am the third party. I don't know anything about the vehicle because we have met with an accident by the motorcycle. EH is a scooter, my lord. EH is not a vehicle, motorcycle. EH is a scooter. EA is a motorcycle, my lord. Even the insurance company has taken the contention and they have produced the RC and says that EH is not involved in the accident and EA is the vehicle number. It is their contention. Thereafter, we have filed an amendment
But EA is
application.
not insured by them is her contention.
No, my lord, EH is an insured. Insured means, my lord, the Xerox copy of the EH is all I have produced for the court, but it has been admitted by the respondent officer that we have made a mistake in mentioning the number, my lord,
Where
in
do you get that?
cross-examination. May I read the cross-examination of the officer,
Read it.
insurance company, my lord?
Yes, read.
RW1, cross-examination for the petitioner, my lord. It is after. I have no personal knowledge about the accident. Lordship, you got it?
Yes.
I have no personal knowledge about the accident. We had first issued a policy for the vehicle number K04EH9558. The engine and chassis number in the policy is 508315. It is true, we have a mistake. We have by mistake mentioned the vehicle number as K04EH9558 instead of number K04EA9558. I don't know that police have filed a case on the basis of a policy particulars. It is false to say that I am taking advantage of our own mistake. It is false to say that it is our and owner's mistake. It is false to say that to escape from life I am falsely deposing. Admitted by themselves, my lord. They have made a mistake in the mentioning the policy.
Have you seen the cross-examination?
Glad I don't have the copy of it.
He himself admits your witness.
Lord, RC is EA. Don't know whether policy is issued for EH. And they have issued a notice to the owner.
Says that I have no personal knowledge about the accident. We have first issued policy for vehicle number KA04EH9558. The engine and chassis number in policy so and so. It is true, we have by mistake mentioned the vehicle number as EH9558 instead of EA9558. That is your officer's evidence.
Lord, if that is the case, if she has, if
Then
they
what-
have said, if the company has said that
No,
by
no,
mistake it is
no.
given.
I'll keep it tomorrow. Please come to the court and look at the court bundle.
Yes, my lord.
This is smarter tomorrow.
If that is the case, my lord, if that is the evidence given by the officer of the company, if they say that by mistake EH is mentioned as
No,
E.
that's what
instead-
I'll read again. I have no
Yes.
personal knowledge about the accident. We had first issued policy for vehicle number KA04EH9558. The engine and chassis number in policy is 508315. It is true, we have by mistake mentioned the vehicle number as KA04EH9558 instead of KA04EA9558.
Lord, if that is
That's
the
why-
admission. I
No.
don't
You please verify this and make your submissions and we'll dispose of on that.
Yes, my lord.
When do you want, tomorrow, day after, or next
Day
week?
after tomorrow.
Day after
Next
tomorrow,
week,
this is
madam.
smarter. Day after tomorrow, at the request of non-counsel for the respondent insurance company.
Cell number 6 adjourned. Cell number 7. 7 adjourned. Cell number 8. Harish Babu, KN. For appellant.
Appear for appellant in this case.
What happened to all these insurance councils? Nobody is here. Where is Mr. PB Raju? Oh, today. Okay.
That's right.
You represent Mr. P. V. Raju?
Bibiraj, I am represent, but.
But it
it
is
is
under
not.
163, a petition got dismissed. So deceased was the driving the vehicle,
So when do you want?
self-accident.
Day after this next week it can become better, because up to 8th is the Adalat.
Let's just matter on 12th,
No,
12th March. the request of
11th,
the
madam.
counsel response.
11th,
11th
11th or
11th,
14th.
11th.
Please.
Much. of-
Till number
And
nine,
Pradeep one case.
nine
it is.
urgent.
That's
Till-
why, Pradeep, that is your lordship has Passover.
Ready?
That is only the license.
Hmm.
Lordship has already argued, I think, lordship.
Oh, yesterday's matter where.
Your lordship, then you have gone through that judgment and all the things. That's why next week better to.
Which one that is?
This is different. ma'am.
Serial number 4.
No, the passed over matter.
Yes, 4. Because he gone to passport office, that's why.
Yeah, for, this is not heard.
That is,
That is a different matter.
that is different, but
That's coming up tomorrow.
correct. This is the analogy same because there is no license also. Which is the owner of appeal also.
I think that matter is coming.
That is
tomorrow.
not, that is not connected. But this is matter same connected with that also. Because of reliance of that.
This matter, where is she? Mahesh BJ.
Mahesh BJ. Till number 4.
We'll have this matter also on 11th.
Sure.
11th, at the request of counsel, the
Obliged, my
respondent.
lord, obliged.
Serial number 4,
Because
11.
what had happened, your lordship?
Huh?
What on that day discussed that is license, your lordship. In this matter, same analogy.
Same issue.
That's why. Because here also owner filed the appeal.
No, it's different. If owner has filed appeal, he will.
And there is no license on that point.
Will stand a better footing.
Yes, that is
Yes,
ECA.
in yesterday's case, it was a driver.
Yes, correct. Here, that is
If it
not
is
so.
owner,
But-
if it is the owner of the vehicle, then
That-
that, what is that, Baliram? what is
That
that?
is
Bailaram.
Bailaram. Bailaram.
Yeah, that will apply.
Yes,
Yeah, next.
better the both are disposed of.
Yes, next.
Much obliged.
Till number 10. Appellant
Yes, my lord.
Harini Shivanand.
10.1. Insurance company is served. 10.
Which insurance company it is?
Harini Shivanand is represented.
1 minute, 1 minute. Where is that panel of particles?
Already represented by.
Oh, then she will only take,
Take notice.
yeah.
Yes,
Yes,
my lord,
madam, you will take notice in the next matter also.
Yes, ma'am. I'll take notice.
In 10.1.
That is by the claimants.
In 10.1,
Next,
Harini
Gayatri.
Shivanand is directed to take notice on behalf of R1.
Urban insurance company.
On behalf of R1 and the land counsel for the petition shall serve a copy of the memo, appeal memo on the counsel appearing for the respondent. List this matter on 19th.
Day after tomorrow.
Till number 11 and 12 urgent. Till number 13. Suresham Latu.
I am for the appellant, my lord.
Who
Is it
appears
serial
as
number
respondent, Ravi Shankar.
11? Is it serial number 11, my
Yes,
lord? 13 I am
11,
reading.
Mr. O Mahesh is not well. He is going for some medical test. He asked for time.
Yes, my lord.
13, Suresh Amlathur, 13.
Yes, my lord.
Yes, this matter also,
A. Ravi-
Mr. A. Ravi Shankar is appearing at the request of learned counsel for the respondent. Plus this matter on 21st, not 21st, 24th of March.
Till
Yes,
number
next.
14.
Oh,
Raman MN.
You're ready?
I'm ready.
14.
No, previous.
My lords, I appear for the
13
petition
one,
in
you're
serial
ready?
number 14.
Sorry, I came a bit late.
Yes, 13.
Lots were to kindly take.
Yes, Mr. Suresh. He left.
Oh, no, he's here.
Yes, Mr.
yes,
Lathur.
ma'am. Yes, ma'am.
Mr. Ravi Shankar is here.
He had argued the matter.
Here, my lord.
He had argued the matter. At that time, he cited some judgments without serving a copy to me. This honorable court directed him to serve the copy to me.
Even till now it is not.
He has given. He has given.
Yes, not sir.
He has, sir.
Yes, sir. Hmm. What is the issue?
It's a case of injury. My learned friend wanted the present act to be enforced, saying that it is retrospective and compensation as per the present act to be given. It is a third party. I am not in appeal. I am an insurance company. I have satisfied the award. If he wants more compensation, he has to satisfy my lords. That's all is the case. So he's saying the 164 of the new act requires application. 164 of the new act will come into force for 163A is gone. 164 has come. This is a 166 application. So all those judgments may not be. If my lords were to get satisfied that the claimant requires enhancement, we don't need to go into any of these provisions of law. If he is entitled for enhancement, my lords will enhance. If my lords finds that an inadequate compensation that is given, regardless of which law requires to be applied, my lords will grant compensation. So all these judgments that he has given of different high courts, though have persuasive value, first we have to satisfy my lords as to the requirement of.
No, there are two MBCs. Which MBC is in appeal now? Order?
66/2016 arises out of MVC 4437/14.
What is the compensation that is claimed?
83,000.
What is granted?
83,770.
Hmm.
So he wants enhancement in this.
So how much granted is 83,000?
Yes, ma'am.
Claimed is?
Claimed 8 lakhs and 10 lakhs. 8 lakhs this claim.
It's a case of injury.
Case of injury. I admit
Any disability?
no disability. Injuries are there. There is an amputation. Right foot, big toe, and second toe amputated. And abrasion of the knee. My lords will get this at internal page 24, para 22 of the judgment. Am I permitted to read that? PW2 being the injured in 4437, the evidence has clearly stated that on 21/8 at about 2:30 p.m., he was proceeding in a motorcycle as a rider. The driver of the offending vehicle, driven the same in high speed and rash and negligent manner, without observing the traffic rules and regulation, dashed against the motorcycle from behind. As a result, he fell down, sustained following injuries. Right foot, big toe, and second toe amputated. Multiple abrasion over both knee, other grievous injuries all over the body. So immediately he was shifted to Specialist Hospital, Bangalore, wherein he took the first aid treatment and is shifted to Ambedkar Hospital, Bangalore. He took treatment as an inpatient, wound debridement and closure with disarticulation of distal phalanx of right great toe and second toe ankle block done on 22/8/14, discharge on 3/9/14 with an advice to take follow-up treatment. So after the discharge, he took the treatment as an outpatient by visiting the hospital once in 15 days for 2 months, monthly, once for 3 months. So he has spent 60,000 towards medical. Prior to accident, he was hale and healthy, studying in commerce. Para 26. PW2 being the injured in his evidence has clearly stated that he has met with an accident, sustained the injuries and amputation of great toe, second toe of his right foot, but the reasons best known to him, not examined the treated doctor, not placed any materials to show that he has sustained any permanent disability due to the accidental injuries, except amputation of greater toe and second toe of right foot. Exhibit P16 is the case sheet clearly reflects about the amputation of great toe and second toe of right foot, but the petitioner has not produced any oral or documentary evidence to show that he has sustained permanent disability due to the accidental injuries. However, he has produced a wound certificate marked as P12. The learned judge passes.
May I submit, my lord?
1 minute. What is the age of the claimant?
25 years at that time. 20 years
20 years, my lord.
at the time of filing the petition.
No, as far as the disability is concerned,
There is disability,
yes, there is amputation.
regardless of examination.
So as per the chart, how the disability is considered, we have to see.
We'll have to go to the workman compensation, line.
Hmm.
The compensation, because he's a student, young boy.
How much?
He's a young boy, he deserves compensation.
20,
I mean,
that's
I
fine.
myself will
Oh.
volunteer. But all those arguments of section
No, let's
164,
not go into that.
he
So,
deserves compensation, he deserves enhancement, because the learned judge is just not
he
given any.
said that he records that there is amputation. And the toes, what is that?
My lord, loss of future earning, what has happened is there is no amount is given.
Hmm,
So
that
he's
needs
a-
to be given.
that request given, so as pain and suffering. I felt that 40,000 rupee to the extent of injuries that he has suffered. He has undergone debridement and all these procedures he has undergone. It's very painful. I'm a lawyer who will never come in the way of these enhancements. But I myself felt that 10,000 is too less, 40,000 is too less.
Hmm.
An inconvenience caused during later period, 10,000 is also on the lower side. I mean, I myself,
Inconvenience.
kindly
to
don't
the-
put my name, but
Inconvenience to the parents.
inconvenience caused to the parents, I don't, I mean, we should go, inconvenience caused to him only. Inconvenience caused to him only, because a young man, any small injury
Hmm.
may result in some kind of a functional disability. May not be a medical disability, functional, he may not be able to carry out the activities
Hmm.
as before. And medical expenses, we can retain if my lords were to,
Hmm. Same as it is.
because he is, and lots of
Conveyance, food, transport. and-
amenities, my lords.
No, amenities separately will deal.
It's
Conveyance, food and transport, 20,000.
request, ma'am.
20,000.
Yes,
Then we have to deal with the loss of amenities and permanent disability.
yes, madam.
On these two counts,
Right.
the compensation needs to be.
Yes.
So no, as per the chart, that amputation is, what is the percentage of disability?
Yeah.
Yes, Mr. Latu.
Yes, I have not seen it, my lord. I don't have workman
That's what is
compensation.
required, required to be seen.
Madam,
He has lost the, what
My-
is that?
my-
His right big toe and second toe.
Yes, my lord. There is
What is
a,
the disability as per the chart? Percentage.
I don't have that act
Yes,
now.
I will assess the court.
Look at.
Now, with regard to the recent amendment to the Motor Vehicles Act, my lord, under section 164, if it is a grievous injury, then 250,000 entitled by the claimants, my lord. Therefore, on that basis, my lord,
250,000 for pain and suffering.
no, grievous injury, the lump sum amount has been fixed by the legislators under section 164 of MA Act.
So you're happy if 2,50,000 is granted as a lump sum amount?
That I am claiming before this honorable court.
I'm myself.
No, if it is independently calculated, it would be more than
Go.
that.
We feel
Yes.
whatever, regardless, the boy should get the compensation. We should not, I'll be doing injustice at least even as an
That's
insurance.
what, you're being satisfied, you're making your client to go satisfied with a lesser amount, with all the judgments.
No, my lord, just
Now,
compensation,
if
he is
the
entitled.
if
He
the
is
permanent
entitled just
disability,
compensation.
My lord, I just gave
Ah.
the right side, I just given a.
loss of all toes, it is 30%.
30%.
Law-
So it is all toes. Here, two are gone. My
Mhm.
lord can take this and maybe 20% we can give.
20%.
20%. Then he gets amenities also, my lords can.
Hmm.
He deserves
If it
that.
is- No, in the permanent disability, if it is 20%, 20% to the whole body.
20% to the whole body.
So what is his income?
Income, my lords, is 20 years. So as on 20, the date
Which
of
year?
accident, 2014.
2014, it is 8,500, I think. 8,500.
Yes, ma'am. 2014 is the date of accident.
8,500
Yes, ma'am. 8,500.
into 12. And what is his,
He's just a student.
is a,
Student. That's what he claims.
he's a student.
Student. He says it is.
Oh, what is he studying?
It's written.
BCom second year, my lord. First year
So what is-
BCom.
Then we were taking the income like in that, what is the judgment? In between, I have lost
Mallika.
touch with that engineering, we were taking something like
In between, my lords can take.
15,000 or 12, something is there.
Earlier, we used to
Yes.
take
Ah.
14. My lords can take 15,000 into 12 into 20%.
Yeah. 15,000 into 12. And what is the multiplier?
18, my
18.
lord, he gets.
18 into 20, 500.
Can I use my calculator? No,
It's coming to 6,48,000.
6 lakhs, if my lords can, via media, we can.
That's why I wanted to take 8,500.
8,000. Three lakh 67,200.
It is still more than what
What is?
Mr. Lathur relying on judgments was
No,
asking.
my lord. The act says minimum compensation.
No, that's what you said, 2,40,000.
Yes.
3,67,000, then loss of amenities? Mr. Vishankar, loss of amenities.
But we can double what the learned judge has given. He has given only 20,000.
We'll make it 50.
Even pain and suffering, my lords can increase.
Pain and suffering, I've granted 1.
Okay. I feel
Could be
it's
less, could be more?
slightly on the higher side, but I will not.
No, because so initially I've already calculated 60,000.
My lords can retain that.
Huh?
My
Huh.
lords can retain. 40,000 is given. My lords can add another
I made it 60,000.
60.
So pain and suffering 60,000, inconvenience to the parents 20,000, medical bills 13,000. Food and transport 20,000, loss of amenities 50,000, permanent disability 3,67,200, legal expenses 10,000.
And judges have awarded 8%. My lords can give.
That will do it to 6%.
Great.
It is coming to 4,90,970. Or shall we make
Right.
it 2,50,000? Please come. It is 4437. Agreed
Yes.
with the orders passed, agreed with the order passed in MBC number 4437 of 2014 dated 10th September 2015, whereby the court had granted compensation of an amount of rupees 83,770. The claimant is before this court. The claim petition is filed seeking compensation of an amount of rupees 8 lakhs for the injuries sustained by the claimant in the accident. It is the case of the claimant that because in the accident, because of the injuries sustained in the accident, he had sustained permanent disability. There is a crush injury with self-amputation of right big and second toe, and there is an abrasion over both the knees. The court has said that, and he was in hospital for 13 days, and he has spent enough money. He has spent substantial amounts for the treatment. The court has held that the accident has happened because of the rash and negligent driving of the driver of the offending vehicle. Considering the amputation, the court had granted pain and suffering at 40,000. Then for the inconvenience caused to the parents, an amount of rupees 10,000 was granted. Towards medical expenses, basing on the medical bills, an amount of rupees 13,770 was granted by the court. When it comes to the loss of future earning, the court observes that the accident has taken place on 21/8/2014, and the claimant took treatment as an inpatient for a period of 13 days, and his right foot, big toe, and second toe is amputated. But for the reasons best known to him, he has not examined the treated doctor, nor placed any material on record to show that he has sustained any permanent disability due to the accidental injuries. In the absence of the oral and documentary evidence on record, question of granting future loss of income does not arise, and accordingly, no amount was granted for loss of amenities, conveyance, food and nourishment, attendant charges. An amount of rupees 20,000 is granted by the court. Altogether, a compensation of 83,770 was awarded. Learned counsel appearing for the appellant submits that considering the injuries that are sustained and the amputation of the two toes, the right big and second toe, the court had not granted any amount on the head of loss of future earning, and even in all other heads, the amount that is granted by the court is not a reasonable amount. He was just 20 years old, and for the injuries he has sustained and the impact it is going to have in his on his future life should have been considered by the court. And he submits that the compensation needs to be enhanced. Next, parallel counsel appearing for the insurance company submits that the court had rightly not granted any amount for the loss of future earning, as no document is placed before the court with regard to the disabilities that is sustained by the claimant. And even on other heads also, the court had granted sufficient amount. He submits that the interest ought to have been at 6%. Instead of that, the court had granted the interest at 8%, which is not correct. Further, on all other aspects, the order of the tribunal needs no interference from this court. Next paragraph. Having heard the counsels on either side, peruse material on record. There is no dispute about the fact that the claimant had sustained injury and his right big toe and the second toe were amputated. The court, having given such a finding that both the toes or two toes were amputated, on the ground that no material is placed before the court to show the percentage of disability, court had to show the percentage of disability, court had completely rejected the case of the claimant as far as the future earning is concerned. This amputation would definitely have an impact on his future life. And the court ought to have taken this into consideration. The boy is 20 years old, and this accident had taken place in the year 2014. Considering the minimum income, considering the notional income at 8,500, and the multiplier is 18, and the disability can be safely taken at 20% to the whole body. Then 8,500 into 12 into 18 into 20, 100 is 3,67,200. Under the head of loss of future earning, he is entitled for that amount. Then coming to the pain and suffering, considering the amputation, the amount of 40,000 that is granted by the court is not an adequate amount, as this court is granting an amount of rupees 60,000. Then inconvenience to the parents. An amount of rupees 20,000 is granted by this court. Medical bills court has rightly granted, and no interference is called for. Towards conveyance, food and transport, this court is granting an amount of rupees 20,000, considering the hospitalization and the amputation and the requirement of the requirement of the claimant. Coming to the loss of amenities, the court had not granted, had clubbed this with attendant and nourishment and granted only 20,000, considering the amputation and the age towards loss of memory, which is going to have a long-lasting effect on his future life. Under the head of loss of amenities, this court is granting an amount of rupees 50,000. In the light of the law laid down in so and so, towards legal expenses, 10,000. Altogether, the claimant is entitled for an amount of rupees 4,90,970. Accordingly, the appeal is partly allowed, enhancing the compensation from 83,770 to 4,90,970. Before that, before this calculation, though the insurance company has not preferred any appeal, in all the cases, the interest that is granted is at 6%, whereas in this case, the court had granted 8%, and the same is reduced to 6%. In the conditions, the enhanced amount shall carry the awarded amount shall carry 6% interest from the date of the order passed by the tribunal till the date of realization. The amount and also the enhanced amount 6%.
Great.
Then number 14.
My lords, I appear for the petition in serial number 14.
Yes.
My lords, this is a petition seeking the letters of administration of a will, my lords.
No, all these 14 to all these the provided CPs will come on 26th March.
My lord, I'm for 16. Serial number 16, my lord.
17 will come on March. What is the date I've said?
26th, my lord.
Yes.
Great.
Yes.
End of the list, memo vote.
For the petition.
Memo a memo is filed seeking to withdraw the petition. It is stated that this court, by order dated 4/3/2025, passed an order directing the arrest of the respondent number 1 vessel. Subsequently, the petitioner has received an amount of a sum of USD 1,001. What is this?
With 1 lakh.
1,31,276 towards the full and final settlement of the claims. Hence, they want to withdraw the petition. Accordingly, the CP so-and-so is dismissed as withdrawn and all the IAs stands closed.
Great.
So the 5 o'clock matter. The 5 o'clock matter, do that. The 5 o'clock matter, if they're ready, ask them to come now itself. Call the advocate.
Just a small submission. The honorable court had the registrar had intimated regarding the arrest. So regarding this, if at all the registrar might communicate to the portmaster, it would be, because they'll be expecting this.
Order shall be communicated, same yesterday's addresses are there.
Yes.
This order shall be communicated to the so-and-so, all that email addresses.
Great.
ಮೇಡಮ್ ಅದೇ ಎಲ್ಲ ಬೇರೆ ಫೈನಲ್ ಇದಾಗಿದೆ ಅನ್ಸುತ್ತೆ ಚೆಕ್ ಮಾಡ್ತೀನಿ ನನ್ನ ಫೈಲ್ಸ್ ಎಲ್ಲ ಇಲ್ಲ ಬರ್ದಿಲ್ಲ ಅಂದ್ರೆ ಜೊತೆಗೆ ಮಾತಾಡ್ತಾರೆ ಹಂಗೆ ಬಂದ್ಬಿಟ್ಟಿದೆ ಬೇರೆ ಫೈಲ್ ಹೋಗಿದೆಯಾ ಅಂತ ಎಲ್ಲೂ ಹೋಗಿರಲ್ಲ ನನ್ನ ಫೈಲ್ ಮಾತ್ರ ಇರ್ಲಿಲ್ಲ ಸರ್ ಫೈಲ್ ನನ್ನ ಫೈಲ್ ಇರ್ಲಿಲ್ಲ ಅಯ್ಯ ಇರೋದು ಮೇಡಮ್ ಅಯ್ಯ ಅಂತ ಮಾಡ್ಲಿಲ್ಲ ಅಲ್ವಾ ನಡೀತಾನೆ 15 ಅಲ್ಲ ಮಾಡಿ ಮೇಡಮ್ ಏನ್ ಹೇಳಿದ್ರು
No, 7
dates
day after tomorrow. ಇಲ್ಲ ಮಾಡಿಲ್ಲ advocate for the respondent is no
ಮತ್ತೆ
delay ಅಷ್ಟೇ. However, that advocate for respondent is not
ಎಲ್ಲ ಮಾಡಿ
7/11/2015 ಬರ್ಕೊಂಡು ಹೋಗಪ್ಪ ಅಂದ್ಕೊಂಡು ಏನು ಅದು ನಾಳೆ ಡೇಟ್ ಇದೆ ಮೆಮ್ಮೆ ಇದು TCR ನಿಮ್ಗೆ ಹೇಳಿದ್ನಲ್ಲ TCR ಅಲ್ಲಲ್ಲ ಇದೆ ಅದು ಏನಾಗಿದೆ ಗೊತ್ತಾ ಬರೀ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಅದು TCR ಇದು TCR ಬ್ರಾಂಚ್ ಇಂದ ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ ತಗೊಂಡ್ ಬಿಲೋ ಮಾಡಿದ್ದಾರೆ ನಾನು ಇವಾಗ ಅದನ್ನು ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂಡಲ್ಲ ಇವಾಗ ಫೈಲ್ಸ್ ಅದೇ ಇವಾಗ ಈಗ ನನ್ನ ಫೈಲ್ಸ್ ಇಲ್ಲೇ ಇರಲಿ ನಾನು ಚೆಕ್ ಮಾಡ್ತೀನಿ ನಾನು ಚೆಕ್ ಮಾಡ್ತೀನಿ
ಮೇಡಮ್ ಇವತ್ತು ಮೆಮೋ ಕೊಟ್ಟಿದ್ದೆ ಇನ್ನೂ ಬಂದಿಲ್ಲ ಅಂತ.
ಮೆಮೋ ಎಲ್ಲ ನಾಳೆ ಬರುತ್ತೆ ನೋಡಿ ಸರ್, ಎಲ್ಲ ನಾಳೆ ಇವತ್ತು ಮೆಮೋನಾ?
ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೆ.
ಎಲ್ಲ ನಾಳೆ ಕಳಿಸ್ತೀವಿ.
ಹಾ ಆಯ್ತು. ಥ್ಯಾಂಕ್ ಯು.
ಯಾಕೆಂದ್ರೆ MSAಗಳು
ಇವತ್ತು ಯಾವ್ದು ಇಲ್ಲ ಈಗ. ಅದೊಂದು ರಿಪೀಟ್ ಮಾಡಿದಾರ ಅಂತ ವೆರಿಫೈ ಮಾಡ್ಕೊಳ್ಳಿ ನಾವು.
MFA MSA ಎರಡು ಬರುತ್ತಲ್ವಾ?
ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅವ್ರು. ಮೇಡಮ್ ಎಲ್ಲ ಮೊದಲೇ ಕನ್ಫರ್ಮ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ನಾಳೆ ಪೋಸ್ಟ್ ಮಾಡ್ಲೇಬೇಕು. ಅದಕ್ಕೆ ಅವರು TCR ಕೆಬ್ಬಿಲ್ ಆನ್ ಮಾಡ್ತೀವಿ ಅಂತಾರೆ. TCR ಇಲ್ದೆಲ್ಲ ಕೆಬ್ಬಿಲ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಆಮೇಲೆ TCR ವೆರಿಫೈ ಮಾಡ್ಬಿಟ್ಟು ಪೋಸ್ಟ್ ಮಾಡಕ್ ಕೊಡಿ.
ಅಲ್ಲೇ ಅಂತ ವೆರಿಫೈ ಮಾಡಿ.
ಇದು ನಿನ್ನೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಿನ್ನೆ ಫೈಲ್ ಪೋಸ್ಟ್ ಆಗಿದೆ. ನೀವೆಲ್ಲ ವೆರಿಫೈ ಮಾಡಿದ್ದೀರಾ ತಾನೇ? TCR ಕೊಟ್ಟಿಲ್ಲ. ನೋಡ್ಕೊಳ್ಳಿ ಕೌನ್ಸಿಲರು. ಯಾಕಂದ್ರೆ ನಮ್ಮಲ್ಲಿ ಯಾವ್ದೆಲ್ಲ ಸುಮ್ಮನೆ ಕೆಬ್ಬಿಲ್ಲ ಅಂತ ಬರ್ಬಿಟ್ಟು TCR ಆಗಿದೆ MSA ಹೊತ್ತು ಅವರು ಕೆಬ್ಬಿಲ್ಲ ಅಂತ ಬರೀತಾರೆ. ಆಮೇಲೆ ಸೇರ್ಸ್ತೀವಿ ಅಂತಾರೆ, ತರಿಸ್ತೀವಿ ಅಂತಾರೆ, ಸೇರ್ಸಲ್ಲ. ಅದೆಲ್ಲ ತಲೆನೋ ಮಾಡ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ಒಂದ್ಸತಿ LCR ಹಾಕ್ಬೇಡಿ. ಹಾ ಹೌದಾ? ಅದ್ರಲ್ಲಿ ಯಾವ್ದೆಲ್ಲ ಒಂದಲ್ಲಿ TCR ಕೆಬ್ಬಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದ್ರಲ್ಲಿ TCR 7311 ಒಂದು, ಅದ್ರಲ್ಲಿ TCR ಕೆಬ್ಬಿಲ್ಲ ಅಂತ ನೀವು ತೋರಿಸಿದ್ದೀರಾ. ಬಟ್ 7311/15 ಇಲ್ಲ ಸಿಂಗಲ್ ಫೈಲ್ ಇರ್ಪ. ಒಂಚೂರು ನೋಡ್ಕೊಳ್ಳಿ. ಯಾಕಂದ್ರೆ B ಫೈಲು ಇಲ್ಲ. ಅದು
ಅಲ್ಲಿ ಫೈಲ್ಸ್ ಜೊತೆ ಎಲ್ಲಾದ್ರೂ ಮಿಕ್ಸ್ ಆಗಿರುತ್ತೆ. ನನ್ನ ಫೈಲ್ಸ್ ನೆನ್ನೆ ಆಯ್ತಲ್ಲ, ಆ ಫೈಲ್ ಎಲ್ಲ ಚೆಕ್ ಮಾಡ್ಬೇಕು. ಇದು ಇನ್ನೂ ಬರ್ದಿಲ್ಲ ನಾನು.
ಅದೇ ಅದು ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಬರುತ್ತೆ. ಒಂದ್ಸತಿ ಚೆಕ್ ಮಾಡ್ಕೊಂಡು
ಅಲ್ಲ ನಾನು ಆದಷ್ಟು ಆದಷ್ಟು ಎಕ್ಸಿರತ್ತೀರಿ ಚೆಕ್ ಮಾಡ್ತೀವಿ. ನನ್ನ ಫೈಲ್ಸ್ ಎಲ್ಲ ಇಲ್ಲ ಆಯ್ತಾ? ಆಯ್ತು ಆಯ್ತು. ಬೇಗ ಕಂಪ್ಲೀಟ್
ಬರ್ತೀನಿ.
ಇಲ್ಲಪ್ಪ, ಡೇಟ್ ಫೈಲ್ ಮಾತ್ರ ಕಳ್ಸಿದ್ವಿ. ಇಲ್ಲೇ ಇದೆ ನೋಡಿ.
ಒಂದ್ಸತಿ ನೋಡಿ ಯಾಕಂದ್ರೆ ಅವ್ರು ಕೆಪ್ಪಿಲ್ಲ. ನಾಳೆಗೆ ಇದೆ. ಆಮೇಲೆ ನಾಳೆ ಇಯರಿಂಗ್ LCR ಇಲ್ಲ ಅಂದ್ರೆ
ಮೇಡಮ್ ಬ್ರಾಂಚ್ ಅವ್ರಿಗೆ ಇವಾಗ ಒಂದು ಡೇಟ್ ಫೈಲ್ ಕಳ್ಸಿದ್ವಲ್ಲ, ಒಂದು ಸ್ವಲ್ಪ ಕಳ್ಸಿದ್ವಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು
ಮಿಕ್ಸಪ್ ಆಗಿದೆಯಾ ಅಂತ ಇಲ್ಲ ಅಂತ ನಾವು
ನೋಡೋಣ.
ನೋಡಿ ಒಂಚೂರು ಮೇಡಮ್ ಕರೀತಾ ಇದಾರಂತೆ, ಒಂಚೂರು ಬರ್ತೀನಿ ನಾನು. ಇದು ಇನ್ನೊಂದ್ಸತಿ ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಒಂದ್ಸತಿ ಯಾವ್ದಾನ ಫೈಲ್ ಅಲ್ಲಿ LCR ಇಲ್ದಿರೋದ್ರಲ್ಲಿ ಏನಾದ್ರು ಇಟ್ಬಿಟ್ಟವ್ರಂತ ಕ್ರಾಸ್ ವೆರಿಫೈ ಮಾಡ್ಕೊ. ಈಗ ಕಳ್ಸಿದ್ಯಲ್ಲ ಫೈಲು ಅದ್ರಲ್ಲಿ ಲಿಸ್ಟ್ ಇಲ್ಲಿ ಇಟ್ಟಿದ್ದೀನಿ ನೋಡು. ಈಗ ಯಾವ್ದೋ LCR ಇಲ್ದಲ್ಲ ಇರೋ ಫೈಲ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಅದು ಕಟ್ಬಿಟ್ರೆ
ಅಲ್ಲ LCR ನಂಬರ್ ಏನು LCR ನಂಬರ್ ಇಲ್ಲ ಅದನ್ನೇ ಇರುತ್ತೆ LCR ಮೇಲೂ ನಂಬರ್ ಇರುತ್ತೆ ಏನು MFA 73 ಇಲ್ಲ ತೋರಿಸ್ತೀನಿ LCR ಮೇಲೂ MFA ನಂಬರ್ ಇರುತ್ತೆ 7311 of 15 7311 ಇರುತ್ತಲ್ವಾ ಈಗ ನೋಡ್ಕೊಂಡ್ರೆ ಈಗ ನೋಡಿ ಯಾರು ಬೇರೆದ್ರದ್ದಾಗಿದ್ರೆ ಸಪೋಸ್ ಮಿಕ್ಸಪ್ ಆಯ್ತು ಅಂದ್ರೆ ನಾನು ಯೂಶಲಿ ಹಂಗೆ ಬರೆಯಲ್ಲ ನೋಡ್ತೀನಿ 755 ಅದ್ರದ್ದು ಅದಕ್ಕೆ ಇದೆಯಾ ನೋಡ್ಬೇಕು ನೋಡಿ ಹಿಂಗ್ ಬರೆದಿರ್ತಾರ ಅದು ಅಲ್ಲ ಅದು ಇದು B5 ಇದೆ ಸರ್ ಇದನ್ನ ಗೊತ್ತಿಲ್ಲ
ಬಾಕಿ ಮಾಡಿ ಅದೇ ಅದು ಅಡಿಯಲ್ಲಿ ಇತ್ತಲ್ಲ ಹಂಗೆ ಏನು ಹೇಳಿ ಸಿಕ್ತು ಮೇಡಮ್ ಅಂದ್ಬಿಡಿ ಅಷ್ಟೇ ಯಾರು ಮಿಸ್ಟೇಕ್ ನಮ್ದು ಅವ್ರದಾದ್ರೂ ನಾವ್ ಯಾರೇ ಮಾಡಿದ್ದೀವಿ ಅಷ್ಟೇನಾ ಆಯ್ತು ಯಾವ್ದು ಡೇಟ್ ಇಲ್ಲ ಅದೇ ಇಟ್ಟಿದ್ದೀನಿ ಈಗ ಅವ್ರು ಬಂದ ತಕ್ಷಣ ಕಳಿಸ್ತೀನಿ ಅಂತ ಮೇಡಮ್ ಬಂದ್ರೆ ಅಲ್ಲ ನಾನು ಈ ತಲೆಯಾರ ಹೇಳ್ತೇನೆ ನಿಮ್ ಬರೆಯೋಣ ಇಲ್ಲ ಅಂತ ನನ್ನ ತಲೆ ಕಟ್ಸ್ಕೊಳ್ಳಿ ಇದ್ಯಾವ್ದು CP-95 ತೆಗ್ದಿದ್ದೀರಿ ರಸ್ಟಿಂಗ್ ಹಾಕ್ಬಿಡ್ಲಾ ಯಾಕಂದ್ರೆ ಕನ್ಫ್ಯೂಸ್ ಆಗುತ್ತೆ ಸುಮ್ಮನೆ
ಅದು ಇನ್ನೊಂದು ಫೈಲ್ ಅಲ್ಲಿ ಅದ್ರಲ್ಲಿ MFA ಪ್ರಾಬು ಇದೆ. ಇಲ್ಲ ಸಿಕ್ತು. 3 ಫೈಲ್ ಹುಡುಕಿ 3 ಫೈಲ್ ತಗೊಂಡೆ. ಇವಾಗ ಏನ್ ದುಡ್ಡು ಕಳಿಸ್ಬೇಕು ಇದನ್ನ ಹಂಗೆ ಕಳ್ಸಕ್ಕಾಗಲ್ಲ. TCR plus B5 7311 sent separately ಅಂತ ಕಳಿಸ್ತೀನಿ. ಇದು ಅದು LCR B5 ಅದು ಅಲ್ಲಿ ಟೆಂಡರ್ ಅಲ್ಲಿ ಸಿಕ್ಕಿದೆ. ಫೈಲ್ ಸೈನ್ ಕಳಿಸ್ದಾಗ ಅದಕ್ಕೆ ಇವಾಗ ಅದನ್ನ ರಿಸೀವ್ ಮಾಡ್ಕೊ ಅಂತ ಹೇಳಪ್ಪ ಕಳಿಸ್ಕೊಡ್ತದನ್ನ ಮತ್ತೆ B5 ತಪ್ಪಿಲ್ಲ. ಅದು ಲಲಿತಾ ಅವ್ರಿಗೆ ಹೇಳ್ತಿದ್ದಿಲ್ಲ. ಇವಾಗ ಅದು ರಿಸೀವ್ ಮಾಡ್ಕೊಬೇಕಲ್ಲ ನೀವು, ಯಾಕಂದ್ರೆ ಅದು ಸಪರೇಟ್ ಆಗಿ ಫೈಲ್ ಜೊತೆ ಹೋಗಿಲ್ಲ. ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ ಫೈಲು, ಅಲ್ಲೇ TCR ಅಂತ ಬರುತ್ತೆ. ಕೊಡಿ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ, ಅಲ್ಲೇ TCR ಅಂತ ಬರ್ತೀನಿ, ಕೊಡಿ ಅವ್ರಿಗೆ. ಅಲ್ಲ ಇವಾಗ ಅದು TCR ಸಿಕ್ಕಿದೆ, ನಿಮ್ಗೆ ರಿಸೀವ್ ಮಾಡಿರೋ ಫೈಲ್ TCR ಅಂತ ಬರುತ್ತೆ. ಸಪರೇಟ್ ಆಗ್ತದೆ ನಿಮ್ಗೆ ತಪ್ಪಿ ಅದನ್ನ ಪೋಸ್ಟ್ ಆಗ್ಲಿ. ಅಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಒಂದಕ್ಕೆ ಎಲ್ಲೋ ಬಿಟ್ಟೋಯ್ತು ಅನ್ನೋದು ಬೇಡ, ಅದು ಟ್ರ್ಯಾಕ್ ಇರ್ಬೇಕಲ್ಲ ನಿಮಗೆ. ಅಲ್ಲೇ ಕೆಂಪಿನ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ. ಇದು B5 ಇದೆ. ತಪ್ಪೆಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ ಇಲ್ಲ ಬರೆಯಕ್ ಹೋಗ್ತೀನಿ ನೋಡಿ. ಹಿಂಗಿದ್ರೆ ನಾನು ಅದ್ರದ್ದೇನಾದ್ರು ನೋಡ್ತೀನಿ. ಏನ್ ಟೈಮ್ ಇದಾವಾಗ ಮೂವ್ಮೆಂಟ್ ಮಾಡಿದಾರಲ್ಲ ಅದ್ರಿಂದ ಅದ್ರ ಜೊತೆ ಮಾಡ್ತಿದ್ದಾರೆ. ಆಮೇಲೆ ಇದು ಎಕ್ಸ್ಟ್ರಾ ಫೈಲ್ ಡೇಟ್ ಬಂದ್ಬಿಟ್ಟು ಬೇರೆದು ಎಕ್ಸ್ಟ್ರಾ ಫೈಲ್ ಹಾಕುವಾಗ ಬರೀ CP ಈಗ ನ್ಯಾಷನಲ್ ಲೋಕ್ ಅದಾಲತ್ MBC ಅಡ್ವೊಕೇಟ್ ಬರ್ತಿದೆ ನಾಳೆ ನಾಡಿದ್ದು ಅಂತ ಇವತ್ತೇ ಬಂದಿಲ್ಲ ಲಾಯರ್ಸ್ ಎಲ್ಲ. ಅದಕ್ಕೆ ಮೇಡಮ್ ಎದ್ಬಿಟ್ಟು ಬೇಗನೆ, ಅದಕ್ಕೆ ಇವಾಗ ನಾಳೆಗೆ ಎಕ್ಸ್ಟ್ರಾ ಫೈಲ್ ಹಾಕುವಾಗ MFA ಹಾಕ್ಬಾರ್ದಂತೆ. ಡೇಟ್ ಏನಿಲ್ಲ. ಹೌದಾ, ಇನ್ನೇನು CP ಹಾಕ್ಬಿಟ್ಟು ಇದು ಅಂದ್ರೆ ಅದಕ್ಕೆ ನಾಳೆ ನಾಡಿದ್ದು ಎಲ್ಲ ಇದನ್ನು ನೋಡ್ಕೊಳ್ಳಿ. ನಾಳೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಇದ್ದು ಪರವಾಗಿಲ್ಲ, ಅಡ್ಮಿಷನ್ಸ್ ಇದ್ದು ಪರವಾಗಿಲ್ಲ. ಒಟ್ನಲ್ಲಿ CP ಏನು ಅರ್ಜೆಂಟ್ ಮೆಮೊ ಅದು ಕೊಟ್ಟೋರಲ್ವ ಎಲ್ಲ ಪೋಸ್ಟ್ ಮಾಡ್ತೀವಿ ನಾಡಿದ್ದು ವಾಚಿನಲ್ಲಿ. ನಾಳೆ ಆಗಲ್ಲ ಅಂತಿರಲ್ಲ. ಹೌದಾ, ಫ್ರೈಡೆಗೆ ಅಯ್ಯೋ ಫ್ರೈಡೆ ಡೇಟ್ ಮಾತಾ ಹಾಕೊಳ್ಳಿಪ್ಪ. ಇದೇ ತರ ಮುಗಿಸ್ತೆ ಆಗ್ಲಿ. ಹಾ ನೋಡ್ಲಿಕ್ಕೆ ಅದು ಇಲ್ಲಾಂದ್ರೆ ಪ್ಯಾಟರ್ನ್ ಚೇಂಜ್ ಆಗುತ್ತೆ ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ. ಅದು ಎರಡೇ ಇರ್ಲಿ ಒಂದು ಇರ್ಲಿ ಮೂರು ಇರ್ಲಿ ಆ ಪ್ಯಾಟರ್ನ್ ಚೇಂಜ್ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ. ಪ್ಯಾಟರ್ನ್ ಚೇಂಜ್ ಮಾಡಿ ಮತ್ತೆ ನೀವು ಪ್ಯಾಟರ್ನ್ ಮಾಡ್ಕೊಂಡು ಬೇಡ. ಅದಕ್ಕೆ ಫ್ರೈಡೆ ಬರೀ ಡೇಟ್ ಮಾತ್ರ ಮಾಡ್ಕೊಳ್ಳಿ, ಬೇರೆ ಆಗ್ತದೆ. ಇವಾಗ ಇದು ನೋಡ್ಕೊಂಡಾಗ ಆಮೇಲೆ LCR ಇದು ಸರ ಅದಕ್ಕೂ ಹೋಟೆಲ್ ಸರ ಅದು ಒಂದು ಬರೀಬೇಕು. ಡಿಸ್ಮಿಸಲ್ ಅಲ್ಲಿ ಸ್ಟೇಜ್ ಏನಿದ್ದಾರೆ ಆರ್ಡರ್ ಏನ್ ಬೇಡ. ಅಡ್ಮಿಷನ್ ಇಯರಿಂಗ್ ಇತ್ತು ಅಂದ್ರೆ ಯಾಕಂದ್ರೆ ಮ್ಯಾಡಮ್ ಏನ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಲ್ಲಿ ಇರೋದು ಮತ್ತೆ ನೇಮ ಇರ್ತಾರೆ ಆಯ್ತಾ, ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ಬಿಡುತ್ತೆ. ಇಲ್ಲಿ ಬರುತ್ತಲ್ವಾ, ಇಲ್ಲಿ ಕಾರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಫೈಲ್ ತೆಗಿತೀನಲ್ಲ, TCR ಅಂತಿದ್ರೆ TCR ಫಸ್ಟೇ ನೋಡ್ಕೊತೀನಿ ಫೈಲ್ ಮೇಡಮ್ ಕೊಡಕ್ಕಿಂತ ಮುಂಚೆನೆ. ಹಂಗಾಗಿ ನನ್ಗೆ ಅದು ಇತ್ತು ಅಂತ ಕನ್ಫರ್ಮೇಶನ್. ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಅಲ್ಲೇ TCR ಮಾಡ್ಕೊಳ್ತಲ್ವಾ ಹೌದು. ಈಗ ಇನ್ನೆಲ್ಲ ಹೋಯ್ತು ಅಂದಿದ್ರೆ ನೀವು ಹೋಗ್ಬಿಟ್ಟಿದ್ರೆ ನಮಗೆ ಗೊತ್ತಾಗಿರೋದು. ಇಲ್ಲ ಇದಕ್ಕೆ ಅದೇ ನಾನು ಅದ್ರದ್ದೇ ರೆಕಾರ್ಡ್ ಹುಟ್ಟಿದಾರ ಅಂತಾನು ಮತ್ತೆ ಕೆಲವೊಂದ್ಸಲ ಯಾವ್ದೋ ಅಲ್ಲ ಇಲ್ದಲ್ಲಿರೋ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಬಿಡಾದಲ್ಲಿ ಬೇಡ. ಬಿಡಾದಲ್ಲಿ ನೀವು ರೆಕಾರ್ಡ್ ಚೆಕ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಆಸ್ತಿ ಹೋಯ್ತದೆ. ಇಲ್ದಲೇ ಇರೋದ್ರಿಂದ ಆಸ್ತಿ ಅವಳು ಅದೇ ಹೇಳಿದ್ರು 4-5 ಫೈಲ್ ತನ್ನಿ ಅದು ಇಟ್ಟಿದ್ರಂತೆ ಯೂಶುವಲಿ ಅದು ಮಾಡ್ಲಿಲ್ಲ ಅವಳು ಅಂತ ಹೇಳಿದ್ರು.